One of the things I'd like to ask. Well, we'll resume the confirmation hearing for Scott Pruitt, EPA Administrator. And Attorney General Pruitt, let me just start by saying sometimes you get a chance to sit down over lunch and you say, I've been answering questions for 2.5 hours. You know, I wish I had said something differently about something or other. Anything that you'd like to clarify?
Just one point of clarification in response to Senator Whitehouse's questions this morning about different environmental enforcement steps we've taken with respect to the leaky underground storage and double dipping in our state. I've initiated officially 3 cases there with respect to Valero, BP, and Conoco. Exxon and a number of other cases are still in settlement discussions, and so those cases have not materialized in actual litigation just yet.
Thank you for that clarification. I had a couple of quick questions. In the city of Cheyenne, Wyoming, it was discovered that trichloroethylene, it's a chemical that's been used by the military to degrease the engines of rocket motors, was seeping into the city's drinking water supply. The Army Corps of Engineers, which was in charge of a nearby former Atlas nuclear missile site, refused to even admit that the site was the cause of the pollution. I fought the Corps on this to do the testing needed to prove what was obvious to everyone who looked at it. The test results showed a large plume coming from the Atlas site directly into the city's wells. The Corps is now addressing the pollution of the city's water supply. It's now protected through a state-of-the-art water treatment facility that's installed by the Corps. But can you give me perhaps an example when you served as Oklahoma State Attorney General where you went after polluters and you held them accountable in that same way?
Yes, Senator, as I indicated earlier, and I think this was indicated in this morning's testimony, I mentioned the case with the hen producing the CAFO, and that was something that we actually initiated. I know there was some question that Senator Carper raised in that regard. That was both with respect to federal and state violations, and we actually joined the state of Texas and the EPA in that enforcement action. But I've submitted for the record, as you know, a list of cases. We've worked with the Wildlife Commission in Oklahoma, the DEQ, around CERCLA matters and enforcement of our state laws.
It's interesting. What was troubling to many of us in the previous administration was when officials within the Obama administration went to extraordinary lengths to avoid disclosing their official written communications under the Freedom of Information Act. This is the law that allows public access to government records. So, for example, EPA Administrator Lisa Jackson at the time used an EPA email account under the name of Richard Windsor, as opposed to her own email account. And so if confirmed, will you refrain from taking any such action that makes it difficult or impossible for the public to access your official written communications under the Freedom of Information Act?
Yes, Mr. Chairman, and as I indicated in my opening statement, I really believe that public participation, transparency, and rulemaking is very important, and I think that extends to this matter as well.
I'll reserve the remainder of my time. Senator Carper.
Thanks, Mr. Chairman. As we discussed before, you're part of, I think, at least 3 lawsuits, Mr. Pruitt. I think one is pending on the EPA's efforts to reduce mercury emissions from power plants. And we know that 50% of our nation's mercury emissions come from power plants, not nuclear plants, but generally fossil fuel plants, largely coal-fired plants. We know that there are more fish consumption advisories in the U.S. for mercury than I think all other contaminants combined, including in your home state of Oklahoma. If you believe that the EPA should not move forward on the mercury and air toxics rule, how do states clean up mercury? What do you think are the health impacts of mercury emissions?
Senator, I actually have not stated that I believe the EPA should not move forward on regulating mercury or adopting rulemaking in that regard. Our challenge was with regard to the process that was used in that case and how it was not complicit with the statutes as defined by Congress. So there's not a statement nor a belief that I have that mercury is something that shouldn't be regulated under Section 112 as a hazardous air pollutant, a HAP, as you know. That section deals with directly health concerns of our citizens. That's the reason why there is control technology that is very heightened in that statute, maximum achievable control technology that is required. And so I believe that mercury should be dealt with in a meaningful way by the EPA, but subject to the processes that this body has outlined.
Senator Lamar Alexander and I worked together for a number of years on clear skies legislation. The George Bush administration had proposed clear skies, dealing with sulfur dioxide, nitrogen oxide, and mercury. And several colleagues of my own, including Senator Alexander, worked on legislation similar. One of the differences between what we proposed and the Bush administration proposed was with respect to reducing the emissions of mercury. I don't recall exactly what the Bush proposal called for in terms of emission reductions from power plants and others from mercury, but it wasn't very aggressive. I proposed a reduction of 80% over a certain number of years. Senator Alexander said he thought that folks could do better than 80%, and he proposed a 90% reduction schedule. We had literally here at this table witnesses from utilities, and one witness from a trade association representing technology companies that focused on reducing emissions of harmful substances into our air and to our water. Every utility representative said, we cannot meet an 80% reduction in mercury. The witness from the trade association representing the industry who's in business just to try to reduce emissions like mercury said, not only can we meet the industry, can they meet those reductions over the stipulated period of time, they can exceed them. As it turns out, they exceeded them. Actually did better than 80%, actually did better than 90%, and did it more quickly than I think was anticipated. Is that instructive to you in any way on this question?
Is that what I'm sorry?
Instructive to you? Is there any lesson there for you or for us from that experience?
Well, as I've indicated, Senator, I really believe that it's important in this partnership between the EPA and the states. I made reference to the phrase earlier, national standards and neighborhood solutions. I think that shows that the EPA can be involved and should be involved in setting standards, setting objective science-based standards to improve air quality and protecting the health of our citizens, but also be a meaningful partner with the states in implementing those laws.
Okay, let me just stop you there, please. I like to say in adversity lies opportunity. That's not me, that's Albert Einstein. But there is economic advantage to be gained from cleaning up pollution. We've seen that there's companies that worked on the mercury emissions. They've made money doing that and installing that technology around the world. Similarly, there has been money made from Diesel Emission Reduction Act, the American technology reducing emissions from old diesel engines. Do you ever give any thought to that, the economic gain, the economic advantage that flow from developing that technology to reduce emissions? I actually think that sometimes setting regulations, clear regulations, and I'll never forget a conversation I had with when we were working on our Clear Skies legislation, addressing 4 pollutants, meeting with a bunch of utility CEOs, and we're talking about how to go forward on that issue. And at the end of the conversation, one of the utility CEOs, I think it was curmudgeon-like older fellow, and I don't remember where he was from, but he said at the end of the day, he said, here's what you need to do, us, Congress, EPA. You need to tell us what the rules are going to be. You need to give us some time, some flexibility, and you need to get out of the way. That's what he said. Tell us what the rules are going to be, give us some flexibility, and get out of the way. Do you believe that actually setting standards, whether it happens to be with mercury reductions or CAFE standards, fuel efficiency requirements, that we're actually setting those standards, making it clear that we actually provide certainty and actually open a door for economic economic productivity or production?
I do, Senator, actually.
Okay. Can you give us an example where you actually saw that happen, were helpful in making that
I mean,
happen?
in Oklahoma, this is not widely known because we're known as an oil and gas state, but in the generation of electricity in our state, 17% of our electricity is generated through wind. And so we've had a heavy emphasis on renewables, and it puts us in top 3 of the country. And so our Corporation Commission, I actually have obligations to appear before the Corporation Commission in the setting of rates. So as utility companies are looking at modifying their facilities to comply with environmental statutes, there is great discussion about how to do that more economically and to achieve the air quality objectives we have under EPA mandates and state mandates. And so I've been very involved in that process through that part of my office.
Thanks, Mr. Chairman.
Thank you, Senator Carper. Senator Capito.
Thank you, Mr. Chairman. And thank you again for being before us, and congratulations on your nomination.
Thank you, Senator.
Yeah. You know, I think that, as you can tell from this committee and really the country is divided on a lot of the issues in and around involving what you're endeavoring to headline here at the EPA. But I think that understanding one another is extremely important, no matter how many times I might say the same thing and somebody else on the other side might say the same thing. It gives me a greater understanding of where they live and how they think the best way to pursue environmental issues are. So in the crowd that just joined us here after lunch are several coal miners who traveled all morning, have been waiting in the hall and made some new friends in the audience there, and I want to thank them for coming, because those are the faces of the issues that I try to address when we're talking about the different facets of the regulatory environment that we see that's been put forth over the last several years. So this question's for you all. In my very first hearing as a United States Senator on this committee, we had the Assistant Administrator, Janet McCabe. She came to testify about EPA's CO2 rules. When I pressed her about why, in the public meetings on the existing plant rules, EPA had not bothered to come to West Virginia, or for that matter, any of the other states that most heavily rely on coal for electricity generation, this is what she said, and I quote, "We tried to. When we were scheduling national level meetings, we wanted to have those in locations where people were comfortable coming." Well, Mr. Attorney General, I want you to be comfortable coming anywhere in this country to talk about whether it's Rhode Island or whether it's West Virginia, Alaska. People need to know that you're listening and you care and that you're understanding the ramifications for the decisions that you make. So this didn't sit very well for me. We had a meeting after that in Beckley, West Virginia, which is the birthplace of the ranking member. And we had Bo Copley there, who was a laid-off coal miner. He talked about, you know, all the hardships of his friends and neighbor. We had the county commissioner who talked about the loss of revenue to the county and how it's impacting the school systems and the real estate values and the bankruptcies of all of the different coal companies and people who have been out of work. So I would implore you to commit today to visit West Virginia, both sides of West Virginia, and to talk to our coal miners and their families, to talk about what the job and economic impacts and how we can work together with both sides to try to get to the intended goal of cleaner air and cleaner water.
Senator, I really appreciate you sharing that. And that's the reason I mentioned in my opening statement the importance of listening and leading. This process that I've been a part of obviously is very new, but I spent time with each of you, many of you, in individual meetings, and Senator Gillibrand talked about issues that were important to her around CERCLA. You've cited concerns and issues that are important to you in West Virginia. I think it's very important, if confirmed as administrator, that I spend time responding, learning, and listening to you in your respective states and trying to be helpful with regard to the environmental issues that you face.
Thank you. Thank you. That means a lot. Thank you. I'd like to just get some clarification on a topic that kind of has been coming up about how many times you as Attorney General have sued the EPA. And you began your statement by saying that the rule of law is very important to you. And then you talked about several of the cases, and probably most of the cases that you brought forward is not challenging the regulations so much as the process or whether the rule of law has been overstepped and the boundaries of the EPA has been the intent of Congress by legislating to the EPA has been overstepped. And the courts have agreed in some cases that this is the case. Could you kind of restate that position on the different actions?
Well,
that you
Senator,
brought?
as I've indicated, I think in response to Senator Sullivan, probably more so than most statutes that are passed by Congress, this body has recognized the very important and vibrant role that the states play in partnership with the EPA at implementing and enforcing our environmental statutes. And many of you have talked about that in your offices, how your DEQ works with the regional administrator. And so when we talk about rule of law, as you deal with mercury, as you deal with CO2, as you deal with water issues around WOTUS and the definition, in those cases, it's important that you do so consistent with the framework that's been established by this body, and it's respected, because that gives confidence to the people that are regulated. You know, when you have an administrative agency of any type that acts inconsistent or tries to enlarge its authority, it really doesn't inspire confidence in those that are regulated, that you're seeing a matter of picking winners and losers and being against certain things as opposed to protecting people. And so that rule of law is not something that's academic in my view. It's not something that's just legal. I think it's important to ensuring good outcomes as far as improving our air and protecting our waters.
Thank you.
Senator Whitehouse.
Thank you, Chairman. Mr. Pruitt, when we left off, we were talking about things that, to quote the chairman, might place you in a conflict of interest but have not been disclosed. And we were talking about the dark money operation that supports the Republican Attorney General's Association. Before we get back into that, let me just ask you this as a hypothetical. If you had raised significant amounts of money for the Rule of Law Defense Fund from corporations who will be subject to EPA's regulation before EPA, with matters before EPA, might that place you in a conflict of interest?
The EPA Ethics Council has said, and by the way, these are career individuals, as you know, Senator. Justina Few is a career person at EPA Ethics. And so as they've reviewed these potential conflicts, I've disclosed all entities that I've been affiliated with.
I understand that, but I'm asking you if you think it might place you in a conflict of interest, because we both understand that the ethics rules that the EPA is enforcing predate Citizens United, predate dark money. And they've said in the letter that they aren't even looking at that because they don't have the authority to. That doesn't mean it's not a conflict of interest. It means that the regulatory authority on government ethics hasn't caught up with this post-Citizens United dark money world. My question is, you're a lawyer, you know conflicts of interest, you've been an attorney general. Might it be a conflict of interest within your definition of the term if you had raised significant amounts of money for this Rule of Law Defense Fund and they had business before, they'll have business before EPA with you? Is that
I think Ms.
a
Few,
potential conflict of interest?
I think, Justin, if you actually did address those entities to the degree that I was never an officer of the super fund that you refer, the super PAC that you referred to earlier, the Liberty 2.0, and so they looked at those entities.
The question was fundraising.
They looked at those
That's the question
entities.
we don't have any answers on, is what you raised.
They looked at those entities to determine what the nature of my relationship was, and then indicated that those would have to be evaluated in the future as cases arose.
But right now, the chairman asked you a question, which is, are there matters that might place you in a conflict of interest that you have not disclosed? You answered no. Might not, having raised significant money, let's say $1 million. Let's say you made a call to Devon Energy and said, I did your letter for you. Raga needs a lot of money. We've got this dark money thing where we can launder your identity, clean off it, and the money will go into Raga. I need $1 million out of you. Might that not create a conflict of interest for you if that were the facts?
Ms. Few has indicated in her letter to me, again, these are career individuals at EPA Ethics, that if particular matters involving specific parties arise in the future, it will be evaluated at that point.
But how would they know if you're not willing to disclose that you raised a hypothetical $1 million from Devon Energy?
Well, those aren't even covered entities under her letter at this point.
That's my point.
But
that may very well create a conflict of interest, mightn't it?
Senator, I did not serve in an officer capacity at that entity. In fact,
You've
I was
said
not
that
involved
already
in any
too,
way.
but that also is not the question. The question is a very simple one. Did you raise money for the Rule of Law Defense Fund from entities that will appear before EPA as potential defendants and subjects of regulation? And if so, how much And what did you tell them? And what did you ask? It seems to me that's not an unusual or
The Rule of Law Defense Fund, according to Ms. Few, would need to be a party in the future for that to be an issue. That's what she's indicated in her letter to me.
So-
At the time, if issues arise in the future, I will seek the counsel of EPA ethics and follow the advice of those career folks to make a decision and recuse if necessary. That is something I'm committed to doing.
At this point, what I deduce from your statement is that if that set of hypothetical facts were true, if you had raised $1 million from a big energy corporation to go through the Rule of Law Defense Fund to support your efforts at RAGA, that is not something anybody should care about, even if that corporation is before you at EPA and subject to your regulation.
Oh, I think it's something that, if presented in the future, that would, just enough you and myself, EPA ethics would evaluate that, and I would take the appropriate steps to recuse.
But how would it be presented in the future if you're not willing to present it now? Why would you present it in the future, not now?
If there's a matter or case that comes before the EPA's authority, that would be something. There's ongoing, as you know, Senator, Ms. Few indicated this in her letter, there's ongoing obligations that I will have, if confirmed, as administrator, to bring those kinds of matters to attention of EPA ethics.
Well, for what it's worth, I think that the Senate has a role in policing this as well, that the whole purpose of advice and consent and the reason there are these government ethics filings is so that we can look at this exact question. And the fact that they haven't been updated to take into account dark money and all these big political organizations that have been created with dark money doesn't take away our Senate obligation to find out what conflicts of interest you will bring to the position of administrator. And it gives me very little comfort that you're not willing to answer those questions here. My time has expired. I'll continue in other rounds.
Yes, thank you very much, Senator Whitehouse. I would like to introduce for the record an article, the Associated Press and the Seattle Times, headline, Ethics Officials Clear Trump EPA Nominee. It says the Office of Government Ethics on Monday released a personal financial disclosure report for Scott Pruitt, currently Oklahoma's Attorney General. The Ethics Office affirmed that Pruitt's disclosures comply with applicable federal laws and rules. His finances, it says, are among the least complicated of Trump's cabinet nominees. Senator Bozeman.
Thank you, Mr. Chairman. I really do find it ironic and hypocritical that we're in a situation that my friends on the other side of the aisle in this committee, using their definition of dark money as elected official, have literally raised millions of dollars of so-called dark money. I'd like to talk a little bit about some of the over-regulatory burden that the states are facing. Air quality in Arkansas is among some of the cleanest in the nation. Despite the progress that the state has made looking forward, trying to do the right thing, the Regional Haze federal plan is going to produce a tremendous economic burden on them. I think it's a prime example of the haphazard regulatory atmosphere that we've had in the past with little input from the states and the stakeholders. For years, the regulatory certainty has prevented businesses from hiring new employees, stunning economic growth. In fact, the National Small Business Association that was just released found that more than half of small businesses have held off on hiring because they don't know what the rules are going to be. You've mentioned several times, can you talk a little bit more about the impact that you've seen in regard to regulatory uncertainty in the state of Oklahoma, the experience that you've had?
Senator, the visibility program, we've had similar challenges in Oklahoma, the Regional Haze program under the Clean Air Act. That section of the Clean Air Act is really quite a bit different than other provisions of the Clean Air Act. It gives primacy to the states in adopting plans to increase or improve visibility. That particular section of the law says that by the year 2064, that we should have natural visibility in some key areas across the country. Oklahoma, several years ago, actually in 2010, under a different administration, both governor and attorney general, submitted a state implementation plan that beat that deadline by decades. But despite that, the EPA came in and rejected that state implementation plan and forced a federal implementation plan on the state, costing consumers quite a bit of money. One thing that I would add that I didn't talk about earlier, we talked about cooperative federalism and the importance of partnership. I've talked about that. You've talked about that. Under this past administration, the use of federal implementation plans, if you combine President Bush, President Clinton, and President George W. Bush, those three administrations combined, they issued 5 federal implementation plans under the Clean Air Act in 3 administrations. This administration has issued 56. So it shows an attitude of indifference, an attitude of trying to be dictatorial in some respects toward the state's role or manipulative of the state's role in a way that's, I think, counterproductive for air quality.
So when you and fellow attorney generals, other stakeholders sue the federal government, whether it's regional haze or waters of the U.S. or whatever, your goal is not to do away with regulation. Your goal is to make it such that the EPA follow their regulatory authority. Is that correct?
Yes, Senator, and that example I provided to you, where the state implementation plan of Oklahoma that was rejected, we actually satisfied the statutory mandate that was under the Regional Haze Program. We reached natural visibility a couple of decades ahead of schedule. The methodology that was used, the EPA simply disagreed with it. And so they used their authority to displace that state plan, costing consumers in the state hundreds of millions of dollars in increased utility cost.
One of the things that I think we've seen also in the last 8 years is tremendous mission creep on the part of the EPA, where they've gotten into areas where they don't have the expertise, they don't have well, expertise, I think, would be the best word in regard to coming out with some of the things that they've done where they lack jurisdiction and haven't really been in the past. Can we count on you to work with the other agencies to take their expertise into careful consideration as we come out with the rules and regulations?
I think interagency cooperation is very, very important. Obviously, with rulemaking, that's something that occurs and should occur, I think, in a very collaborative way. And so, yes, Senator, I believe it's very important as the EPA conducts its business that it works with the Corps, it works with other agencies at the federal level to ensure that it's doing all it can to advance and protect water quality and air quality, but do so within the framework established by Congress.
And doesn't feel like it's the ultimate decider, again, when they sometimes do not have the expertise of the other agency.
Yes, Senator.
Very
I agree.
Good. Thank you.
Thank you.
Thank you, Mr. Chairman.
Thank you, Senator Bozeman. Senator Merkley.
Thank you, Mr. Chairman. Mr. Pruitt, are you familiar with this piece of medical equipment?
Yes, an inhaler, it looks like.
Yes, an asthma inhaler. Are you familiar with how many Americans have asthma?
No, Senator, I'm not.
Well, it's about 1 out of 10 Americans, including over 7 million children. So it's a pretty significant health problem across the country. And I know I've been fortunate not to have asthma, but some folks I know who have and have asthma attacks feel like they're suffocating. And sometimes they go into crisis. People go into crisis with asthma. Sometimes they die from it. So it's a terrifying condition. And the EPA in October 2015 strengthened the national ambient air quality standards for ground level ozone. They strengthened it to 70 parts per billion, adjusting it from 75 parts per billion, because they argued that it was an attainable standard that would save $3 to $6 billion, and in addition, of course, greatly improves the quality of life by diminishing the amount of asthma attacks and deaths. And you challenged this. You launched a lawsuit against this standard. And was the basis of your lawsuit cost-benefit analysis, that they didn't follow their process?
It was not, Senator. As you know, under the NAAQS program, the Whitman decision, cost cannot be considered in a criteria pollutant.
And what was the standard that you were challenging?
It was a records-based challenge that the need to ratchet down from 75 parts per billion to 70 parts per billion. As you know, the 75 parts per billion had only been in operation for 2 years. And I think, Senator, it's important from a priority perspective, a resource perspective of the EPA, when 40% of the country is in non-attainment for one of those criteria pollutants, perhaps there should be focus on how to meet the level already in statute or already in rule.
So you challenged this based on the attainability standard? I already know that's
so it was a records-based challenge, yes.
Yes, it's attainability standard. And there were numerous groups that weighed in and said, no, this is totally attainable. And I'll submit a list for the record of that, Mr. Chairman.
Without objection.
And the key to this is that by implementing that, by the time it's implemented, It would save annually 230,000, an estimate, of course, asthma attacks among children, 160,000 missed school days, a tremendous number of missed work days, 630 emergency room visits, and 340 cases of acute bronchitis. But it also would save, best estimate, 320 to 660 premature deaths. So here is something that profoundly affects the health of folks in Oklahoma and folks across the country, folks in my home state of Oregon, something that expert after expert said is fully attainable. And you challenge it not on a process issue, that is not on whether or not there was a cost-benefit analysis, because as you rightly pointed out, cost is not allowed to be a factor, but whether it was attainable. So why fight so hard on the side of the oil industry rather than fighting on the side of the health of the people of Oklahoma?
Senator, let me say to you with respect to the NAAQS program, when you look at the non-attainment we have in this country, it's presently around 40%. I think increasing the non-attainment percentages as opposed to focusing resources to get non-attainment into attainment is a very important role of the EPA. We should be taking those marginal and moderate areas in our map that are non-attainment and work with local officials, those counties, through monitoring and assistance to help move from non-attainment to attainment. That is a very important goal of the EPA in each of these countries.
Thank you. You've made your point clear. I just simply disagree with you. None of these standards, when they are set, are attained. That is the point. It is an objective to be worked at over time. There was a strategy that this might take until 2025 to be fully implemented. But in the course of laying out that vision and having folks across the country work towards that vision, you end up saving a tremendous amount of money and a tremendous amount of lives. And I, as a senator from Oregon, fighting for the quality of life of Oregonians, deeply resent folks fighting for oil industry that are trying to damage the health of my constituents and Americans across this country. It is a question of values, and valuing profits of companies over the health of our citizens is a character issue, and that is what these hearings are all about. We are charged with Hamilton to determine whether or not an individual is a fit character. To me, this is a character issue, valuing profits over people's health. Thank you, Mr. Chair.
Thank you, Senator Merkel. I'm submitting for the record a report by the National Black Chamber of Commerce entitled Potential Impact of Proposed EPA Regulations on Low-Income Groups and Minority. The report goes from 2015, goes on to say that EPA regulations, including its regulation on carbon dioxide emissions, would result in the year 2020, nearly 200,000 black jobs would be lost and more than 300,000 Hispanic jobs would be lost. And additionally, there'd be commencement with this, a medium household income, significant decreases throughout the communities listed in the report. Senator Fisher.
Thank you, Mr. Chairman. And here we go again on round two. So I'm happy that we have an opportunity to continue questioning with you, General Pruitt. Nebraska, much like Oklahoma, is a rural state. And with many cases, the closest town or the neighbor can be located miles and sometimes hours away. In Nebraska, 1 in 4 jobs is directly tied to production agriculture. Under this administration, farmers and ranchers felt especially targeted by the EPA. For example, in 2011 and 2012, EPA Region 7 conducted aerial surveillance or flyovers of feed yards in my state. While flying over my state, EPA documented these facilities with photographs. This was very disconcerting to me, given that many livestock producers in Nebraska also live and raise their families on these properties. Not only were these producers not informed beforehand, but the EPA has already delegated the authority to carry out the Clean Water Act in Nebraska to the State Department of Environmental Quality. What will you do to ensure that the EPA sticks to its core mission? And furthermore, how will you work with the regulated community, including agriculture, to build trust among constituencies that have been, I would say, the subject of bullying tactics by this EPA that we have now?
Senator, as I indicated in my opening statement, some core themes, if confirmed as administrator, that I would seek to comply with. One is public participation, full participation, to ensure that all voices are heard as the EPA conducts its activities with respect to rulemaking particularly. And I think that perhaps what you're referring to is a lack of that voice or opportunity in the last several years. And so I would work to build a collaborative relationship with those states. As I've indicated, I think the departments of environmental quality at the state level are valuable partners that we need to restore their confidence in the partnership with the EPA, and then seek to listen to the community concerns in addressing and responding to environmental issues.
Thank you. In one of her exit interviews, EPA Administrator Gina McCarthy has admitted that she has had a bad relationship with agriculture and with the agriculture community, and she listed it as one of her regrets. I think a bad relationship is an understatement in this case. This administration's EPA philosophy is diametrically opposed to the idea that farmers can be good stewards of our land, our water, our environment. And instead, it seemed that this administration's EPA wanted to regulate, and in some cases, it looked like they wanted to prevent farming. The agriculture community is looking forward to a new leadership at the EPA and working with you. And Mr. Chairman, I have here some statements from agriculture officials and groups that I would like inserted into the record.
Without objection.
And if I may, I would close by quoting a few of those. Jim Reese, the Oklahoma Secretary of Agriculture, says that Scott Pruitt will continue EPA's efforts to protect our environment, but with respect towards landowners, taxpayers, municipalities, businesses, and Congress. That is nice to hear, sir. Troy Stowater, Nebraska Cattlemen President, stated, simply put, Mr. Pruitt sees clearly that agriculture and environment are not opposing terms, but rather they are complementary. He will work to cultivate the relationships which will lead to the United States leading in food and fiber production while improving the environment in which it is accomplished. Again, I am happy to look forward to that relationship being established again so that all parts of our society here in this country can participate and receive the recognition that we are good stewards of the land. If confirmed, what will be your relationship with the agriculture community? Are you going to enforce current laws? And will you also respect the limits that we have on those laws?
Yes, on both accounts, Senator, and also the theme that I mentioned in my opening statement that I would highlight again is that we need to reject this paradigm that if you're pro-energy, you're anti-environment, if you're pro-environment, you're anti-energy. I believe that we as a country have demonstrated we've made great progress since the 1970s in improving our air quality and protecting our waters. We can grow an economy and also protect and be a good steward of our environment, and we need to restore that proper balance and commitment to both as we seek to do our job.
Thank you. As I said earlier, every member of this committee believes in clean air, clean water. We want an environment that is respected, where we can manage our natural resources in a responsible manner. So thank you, sir.
Yes, ma'am.
Thank you, Senator Fisher. Senator Cardin.
Thank you, Mr. Chairman. Mr. Pruitt, I want to try to get your understanding. I heard you say that you want to see the regulations and the laws predictable so that the stakeholders know exactly what is required, so there's no confusion. So I want to concentrate on the waters of the U.S. because ever since the Supreme Court decisions, there has been an uncertainty as to what waters are in fact subject to regulation by the federal government and what waters are not. Do you believe that that clarity should be set by statute, or should it be set by regulations from the EPA?
Senator, I think it's a great question. And you look at the series of cases going back to Bayview all the way to Rapanos. I think that you're exactly right. The definition in the Clean Water Act says that navigable waters are waters of the United States. That doesn't provide a great deal of clarity to those that administer the law. And I think the EPA taking steps to provide clarity is important, absent Congress responding. So I think that perhaps there is a time and place for Article I response, congressional response to what this body means when it says navigable waters or waters of the United States.
And of course, the Congress, for whatever reasons, for a long period of time, has not been able to respond as to what we think the definition of the waters of the U.S. should be. The administration did come forward with proposed regulations which were resisted by many of the stakeholders that you are aware of. How would you, how would you define the waters of the U.S.? What was wrong in the regulation? I don't want to go through all the details, but tell me, where do you think we should regulate? You already said more than just navigable. So how do we define it? How do you do it? What did the administration do wrong?
The challenge up until now with respect to the current rule, and this involves actually an error case, the UARG case, where Justice Scalia talked about the counterbalance to Massachusetts v. EPA, where the steps taken by the EPA to take the endangerment finding in 2009 that dealt with Title II mobile sources and then link that over to the PSD program was something that Justice Scalia said transformed the statute and was not lawful or constitutional. I think the same thing perhaps is going on with the current rule. There really isn't, when you are classifying dry creek beds in southeast Oklahoma that are dry 90% of the year as a water of the United States, that clearly is something that historically doesn't fit.
So the administration, in its regulation, had certain exceptions that tried to deal with that. You obviously didn't think those exceptions were clear enough.
Well, actually, the Sixth Circuit said that those clarifications were not sufficient. I would agree with you, Senator Cardin, that I believe that clarity around this definition, the jurisdiction of the EPA, is essential to get right and to address. And as I indicated earlier to some questions, the Supreme Court has actually taken up a matter from last Friday. It's more jurisdictional and not merit-based, but the response by Congress, the response to provide clarity, perhaps is a very important step to take.
Well, I want to pursue this, and I think we've asked questions for the record as to specific provisions that you believe should be in that rule that would be different than the proposed rule. And I appreciate a response to that so we can try to see where we're heading in your thought process as to how you define the regulated waters of the U.S. That would be helpful to us.
And I think, Senator, the reason that's difficult, as you know, is because in that process, whatever process that would take place, that would be rulemaking, which means that there would be comment.
I understand that. I'm not trying to get every I dotted, every T. Just want to get your philosophy as to where the waters of the U.S. lines would be drawn and where you took exception to the regulatory efforts of the Obama administration. Let me get to the second point, if I might, on fracking. Fracking is an interesting area because it's state regulated principally. There's very few federal regulations. There's been, and my state has gas deposits that could be subject to fracking, and Pennsylvania, our neighboring state, has done that. There's been some problems with pollution in water. We know about the gas releases already been talked about. There's some concern, particularly with deep well drilling, that when you inject the fluids back into the cavities, that it may cause instability. In your state, I know there were a lot of earthquakes. There have been talk about how whether these earthquakes were motivated by the fracking activities or not. How well have the states regulated fracking, and where do you see the federal role should be in protecting our environment from fracking?
Well, I mean, I'm glad you mentioned the state role, because we've actually been regulating hydraulic fracturing in Oklahoma since the late 1940s, early 1950s. It's not a new process. Horizontal drilling is, but the hydraulic fracturing process is not, and many states have been very aggressive at regulating for a number of decades. With response to the seismicity issue that you're talking about, the earthquakes in Oklahoma, the Corporation Commission has actually declared off-limits certain drilling activity in hot spots already. They've taken a very aggressive approach, and I, too, share their concern. I've been in conversation with commissioners at the Corporation Commission. That's who has jurisdiction in this matter, and they have taken, again, very meaningful steps to declare off-limits certain drilling activity to try to see if it will help reduce the number of earthquakes happening in Oklahoma, and it has helped.
Thank you. Thank you, Mr. Chairman.
Thank you, Senator Cardin. Senator Inhofe.
Thank you, Mr. Chairman. I have two unanimous consent requests. I don't start my clock yet. One is, I really believe, and perhaps I'm overly sensitive to this, but that Mr. Pruitt's integrity has been put into question with the accusations of contributions to his campaign. I'd like to keep in mind that the oil industry is a huge industry in my state of Oklahoma. They have things called PACs where the middle income people will say, yes, we are, they supported me also. But I think we need to have in the record that there are some things that are going on that should not be going on. And this affects the Democrats, not the Republicans. There's a guy named Tom Steyer, and I'm going to put this in the record, who actually said he was going to put $100 million into campaigns of individuals talking about the global warming and what he expected. In 2016, he didn't do that. He only put in, 75 million of his own money. In 2016, he was the largest contributor, putting in $86 million of his own money. I'm not going to read this because it does reflect the names of people who are at this dais. I ask that this unanimous consent that this be
Without
objection.
objection.
The other thing.
Reserving the right to object. Let me just ask for a clarification from my friend from Oklahoma. The monies that you're referring to, were those donations that were disclosed, fully disclosed?
Oh, yes, I believe there were.
Then that does not sound like dark money to me.
Well, it's all right. Anyway, on the last question that Mr. Pruitt had concerning the earthquakes, I'd like to make this a part of the record because it'll surprise you guys that the Oklahoma Corporation Commission has really focused in on this thing and talked about this is wastewater and disposal wells that we're concerned with. They clamped down on it, and you're exactly right in your response to the question, except you didn't go far enough. In 2016, they actually reduced the earthquakes by 31%. And so we are doing in the state of Oklahoma something that is we've been complimented about the fact that we are taking these actions. So I'd like to make this as a
Without
part
objection.
of the record. Now, the other thing I want to bring out, and I've done this before, but I wasn't going to do it until people kept talking about the science is settled, the science is settled, the science is settled. And I know that people want to believe that. But I remember so well, yeah, go ahead and start the clock, that's fine. I remember so well.
We just want to make sure that the clock doesn't just get stopped for the Republicans and runs for us.
You are alert, I'll say that to my friend. Anyway, I can remember when I was going to go over to every year the UN has a big party and they invite everyone to come in and I was going to go to Copenhagen to be the one-man truth squad, which I did, and I went over there. But during that time, right before I left, I asked the administrator of the EPA, the job that you're, I believe, going to have, Lisa Jackson, I said, I have a feeling once I leave town, you're going to come up with an endangerment finding, and you're going to give you justification for getting involved in this issue. And she smiled so I could tell it was true. And I said, when you do this, it has to be based on science. Tell me the science that you are going to use for this. And she said, well, the IPCC, Intergovernmental Panel on Climate Change. Now, as luck would have it, my luck, not theirs, right after that is when ClimateGate came. And that's when it was disclosed that the individuals, the scientists in IPCC, rigged the numbers and came up with such an outrageous lie in terms of what causes global warming, all of that. And I'll just read a couple of them here. One of the physicists in the IPCC said ClimateGate was a fraud on a scale I've never seen before. Clive Cook with the Financial Times said the closed-mindedness of these supposed men of science is surprising even to me. The stink of intellectual corruption is overpowering. And the UK Telegraph, that's one of the largest in the UK publications, they said it's the worst scientific scandal of our generation. Now, nobody talks about that, but that's the science that they are talking about, and I really believe it's necessary to have that as a part of this record, of this meeting. Now, General Pruitt, in 2012, the EPA and the National Highways Traffic Safety Administration issued updated fuel economy standards that were the result of a compromise, and that compromise was between the Obama administration, the automakers, and the state of California, right? And the part of this deal required a review of these regulations in 2018 before, and these are their words, not mine, before any new standards were put in place. After losing the election, however, the Obama administration broke the deal by prematurely issuing new regulations. This decision was made unexpectedly and well over a year before the EPA said that they'd make the determination. This shortened a time frame and process is concerning. So, Mr. Chairman, I do ask unanimous consent that the previous EPA timeline for the expected action on the midterm review be included in the record.
Without objection.
And Attorney General Pruitt, as administrator, will you look into this matter to see whether this extreme action was appropriate or a hasty political decision?
Senator, as you indicated, the obligation was to meet the November 2008 midterm review, 2018 midterm review, and I think the study that was completed was finished December 30th, and they issued their findings within 14 days. That time period is something I'm not sure that normally happens as far as the time, the velocity of 14 days, but it merits review, and I would review that. Yes. Sir.
Well, the follow-up question would be, would you commit to sitting down with the Transportation Secretary, Elaine Chao? And I've already talked to her about this, incidentally. So both of them will be confirmed, I'm convinced, and you're working to address the impacts of the EPA's decision on automobile manufacturers and consumers.
Yes,
You worked with her on that, in that issue?
absolutely.
All right. Very good. Thank you, Mr. Chairman.
Thank you, Senator. Senator Booker.
Thank you very much. Thank you, Mr. Pruitt. I just want to jump in to one of the areas that you've said is a principal part of one of your achievements. In your opening statement, you said that as Attorney General, you confronted with an important water quality issue on the scenic Illinois River about the high phosphorus levels that were causing a range of problems that come from the manure, principally from farm animals. And you go on to state that this was a historic agreement to clean up the river. It was in your opening statement, a number of the other documents that you provided. You also described the agreement with Arkansas as an important agreement to reduce the pollution, again, that was a result from poultry growers. And I'm quoting you actually directly, that was occurring as a result of pollution from poultry growers. You're familiar with this?
Yes, also discharge from municipalities in northwest Arkansas as well.
I think that's an important point, yes.
Yeah.
I would like to ask you just some questions about this, but I think it's important. I really dug into this and did some research. Can you hold this up? I just want to go through my colleagues what the fact pattern is that led to this moment where you intervened. And it really starts with a Supreme Court decision way back in 1992, Arkansas versus Oklahoma. I imagine you're familiar with the Supreme Court decision that resolved the lawsuit between those two states that held that basically upriver states, such as Arkansas, must comply with water quality standards that are adopted by downriver states and then approved by the EPA. You're familiar with that?
I'm familiar with the litigation, yeah.
So after that Supreme Court decision, effective July 1st, 2002, Oklahoma actually did adopt a .037 water quality standard for phosphorus. And importantly, they gave a decade, 10-year phase-in period before full compliance was required. And then in 2003, your predecessor, Drew Edmondson, negotiated an agreement with Arkansas, which I've read, called the Statement of Joint Principles and Actions. And Mr. Chair, I'd like to enter that for the record.
Without objection.
And then in 2003, to give more teeth to this goes to what you were saying about municipalities, it created phosphorus limits for municipal discharges. And that 2003 agreement, also that I've read through, also states that Oklahoma will reevaluate the .037 criteria for total phosphorus in Oklahoma's rivers by 2012. And then, this is the big part, in accordance with the instructions, the mandates of the Supreme Court, the EPA gave its approval to Oklahoma's .037 phosphorus standard. This was critical because under the Supreme Court decision, now Oklahoma had a water quality standard approved by the EPA that was now enforceable against upstates like Arkansas. Now, let's fast forward to April 2012. Oklahoma's Water Resources Board reviewed the best scientific information available in 2012. It reevaluated and reaffirmed the .037 phosphorus standard. Mr. Chair, I want to put in an executive summary of that review.
Without objection.
And then on June 30th, 2012, the 10-year phase-in, going back to the Supreme Court decision, the actions by Oklahoma, the 10-year phase-in period was completed in full compliance with the .037 became required. It became now what was required by the states. So just to recap all of this, because it's a lot, 20 years, Oklahoma's EPA approved a 0.37 phosphorus standard, more than 2 decades in the making. It had just been reaffirmed by the Oklahoma Water Resources Board, and then the 10-year compliance period phase-in had expired. And so when you said that you had entered into a second agreement with Arkansas, that in your words was a historic agreement to clean up the river, that would reduce pollution from poultry growers, and this is the question that I have, sincerely, I pulled that 2000 agreement and read it, excuse me, the 2013 agreement and read it, and it was stunning to see that it actually didn't take any steps to reduce pollution, but actually only proposes another unnecessary study and attempts to suspend compliance that was 2 decades in the making with the 0.37 standard. It suspended compliance for yet another 3 years of pollution. Isn't that true that that's what the agreement did?
It isn't, Senator. There was actually no enforcement of the .037 standard taking place on Arkansas's side of the border. The reason you referred to the memorandum of understanding, I actually have the second statement of principles here before me as well. That expired in 2012-13 timeframe, and that's what presented my office with the opportunity to go to Arkansas to ensure that the .037 standard would actually be enforced from a state law perspective on that side of the border. That had never taken place in history. You mentioned the EPA. There was no enforcement authority that had taken place on that phosphorus level by the EPA. Oklahoma had it, as you've indicated, as a standard, but it was not being enforced upstream in Arkansas, and that's what the agreement addressed.
Mr. Pruitt, so I don't have the seniority or the stature or the grandchildren of Senator Inhofe, so I can't go over my time. But I will say this. In my next round, I will go back into this because the documents don't seem consistent at all with what you're saying, and I'd like, in my next round of questioning, to go into a little bit deeper into this historic settlement. Thank you, Mr. Chairman.
Thank you, Senator Booker. I would introduce for the record an article that appeared in the Tulsa World this past January 12th, 2017, going way beyond the 20 years of that panel, but of the last slide, but 33 years, and it's by Ed Feit, who served as the agency administrator of the Oklahoma Scenic Rivers Commission from September of 1983 until June of 2016, 33 years. And his statement in this op-ed that he wrote is, "I have found that Pruitt has always done right by our scenic rivers. He has, for the first time ever, he has gotten the state of Arkansas, which happens to have parts of the streams we've designated as scenic rivers originating in and flowing through their state, to agree to Oklahoma's scenic rivers phosphorus standard, an incredible environmental accomplishment, the effect of which cannot be understated." Senator Rounds.
Thank you, Mr. Chairman. Attorney General Pruitt, in August of 2016, the EPA Inspector General found that the EPA had failed to follow through with its commitment to update its 2010 life cycle analysis for corn ethanol, and has also failed to perform its legally required comprehensive study on the environmental effects of the RFS, or Renewable Fuel Standard. EPA's information on ethanol's life cycle emissions is inaccurate, and it's outdated. Today's best available science shows that blending ethanol into gasoline can significantly reduce greenhouse gases. However, the EPA has failed to update its own science with most recent best science that is available, and continues to rely on outdated, inaccurate science when setting national policy, regulatory biofuels policy. What are your thoughts on the EPA relying on outdated, inaccurate science to set federal regulatory policy?
Senator, I think it's the obligation of the EPA in taking steps, rulemaking and otherwise, to ensure that it has the most up-to-date, objective, scientific data possible.
Let me follow up a little bit. The current EPA process for considering the scientific information underpinning major regulations, I believe, is flawed and it's unbalanced. For example, the Scientific Advisory Board, or the SAB, is to provide scientific advice to the EPA administrator and Congress, but there is a significant lack of geographic diversity, and state and local and tribal representation on the SAB. Can you explain to us what your views are on the agency science and what you envision as the role of agency science at the EPA?
Senator, as you and I talked about in our meeting, I think it's important to have that geographical representation better represented, and that there's some conflicts of interest application with the Science Advisory Board that need to be addressed as well, and also with the Clean Air Science Advisory Committee, which is a standing committee of the Science Advisory Board.
I've got a chart that shows the geographic makeup of the 2015 chartered SAB. Of the 54 members, the majority of them come from East or West Coast states. Can you get that chart for me, please? I've also got a chart that shows the number of states that have government representatives on the SAB. How would you broaden the geographic scope of SAB members to make certain that states and various governmental entities are represented? The one on the left shows the lack of diversity with regard to the actual members on the board. And the one on the right actually shows that we have a grand total of 2 states with representation for state and local units of government on those boards.
Senator, if confirmed, it is an issue, as I've indicated, and we talked about in your office, that it's important to address to ensure that there's confidence that as science is driving rulemaking, that it's objective and that it's tethered to the rules that are adopted by the EPA. So this is a very important issue that needs to be evaluated and discussed, and to ensure the efficacy of the science that occurs at the EPA.
Would you commit to us that you would make it an effort to see that the Science Advisory Board actually reflects some fairness with regard to geographic diversity, as well as recognizing the important role that local and regional governments, state and local governments have in determining or at least participating in these boards and commissions?
If confirmed, I look forward to working with you on that issue.
Thank you. Let me finish real quickly with just one other item. And we've listened a lot to whether you're working on behalf of industries, whether you're working on behalf of the folks from Oklahoma, your role as an administrator with regard to clean air, water, and so forth. As the Attorney General, you represented the interests of your state, both your state's economy and your state's environment. But just because you are pro-economic development and pro-economic development growth, it does not mean that you have to be anti-environment. Preserving the environment and preserving the economy, I don't believe, are mutually exclusive. I don't think you've got to choose between the two. How would you balance economic growth with making certain that we have clean air and clean water?
Well, I think part of it's inherent in the statutes and the process that the EPA is supposed to conduct. I know that sometimes rulemaking is seen as something that's not terribly important or something laborious, but the reason rulemaking, the reason Congress has said that you offer notice on a proposed rule and you take comment is it's needed to make sure all voices are heard and that there's an informed decision that regulators are making before they finalize rules because of the impact that it has on the economy and on the environment in this instance. So rulemaking is something that we should take seriously and that we should do so consistent with the framework outlined by Congress so that all those voices are heard that you're referring to, Senator, in the rulemaking process.
Thank you. Thank you, Mr. Chairman.
Thank you very much, Senator Round. Senator Markey.
Thank you, Mr. Chairman. Mr. Pruitt, earlier today you said that the EPA has an important role in regulating carbon dioxide because of the 2007 landmark Supreme Court ruling in Massachusetts versus EPA. The EPA administrators for both President Bush and President Obama made a decision that carbon pollution poses a danger to America, otherwise known as the endangerment finding. Will you promise to keep on the books the scientific finding that carbon pollution poses a danger to the American public health and welfare?
Two things, Senator. First, with respect to Mass v. EPA, the Supreme Court said to the EPA that they had to make a decision.
That's right.
To determine whether CO2 posed a risk. And as you indicated, in 2009, they did so. That is the law of the land, those two cases. There's an obligation of the EPA administrator to do his or her job in fulfilling Mass v. EPA and that endangerment finding from 2009.
So you will keep that scientific finding on the books?
The endangerment finding is there and needs to be enforced and respected.
Okay, and you will not review that scientific finding?
There's nothing that I know that would cause a review at this point.
That's very good. Massachusetts versus EPA made it possible for states like California and Massachusetts to set higher standards for the fuel economy of vehicles using their authority under the Clean Air Act. This is a powerful tool for states to reduce emissions and address global warming. As a direct result of the Clean Air Act authority combined with my 2007 fuel economy law, the Obama administration reached an historic agreement with the auto industry's support to increase fuel economy standards to 54.5 miles per gallon by 2025. Those standards are projected to reduce our dependence on foreign oil by more than 2 million barrels a day, prevent 6 billion tons of carbon pollution, and save consumers more than $1.7 trillion at the gas pump because their cars will be so much more efficient. Those standards are also unleashing a Tesla revolution, clean energy vehicles all across the country. 10,000 people are going to be employed, for example, in Nevada, in this technology area. You've said that you want states to play a larger role in environmental regulation. In your 2015 testimony before the House Science Committee, you wrote, quote, "The EPA was never intended to be our nation's frontline environmental regulator. The states were to have regulatory primacy." But earlier today, you wouldn't commit to maintaining California and Massachusetts and other states' ability to be regulatorily primacy as the leaders of the effort to protect their own state, to do what is best for global warming in their own states. So I'm going to ask you again, will you support the statutory right of states to do more to reduce dependence on foreign oil, reduce global warming pollution, save money at the gas pumps, and create tens of thousands, hundreds of thousands of jobs in the clean car job business?
I think, Senator, generally the answer to that would be yes, but in application with the California waiver that was discussed earlier, that's an adjudicatory process that I can't prejudge what would occur there. As you know, previous administrators have either granted or denied that based upon a record that was made. I do respect and do believe that states have a very important role. We've acknowledged that, or I've acknowledged that today with respect to the Chesapeake Bay situation as an example. And so I will look at that issue like others to make sure that it's respected, but also is consistent with the statutory framework that you've outlined.
Do you support the law that says that California has a right to ask for a waiver?
It's statutory, and it's something the administrator has an obligation to do. So yes, I do respect it.
Do you support the current California waiver for greenhouse gas standards?
Senator, that's what would be evaluated, and I think it's very difficult, and we shouldn't prejudge the outcome in that regard if confirmed as administrator.
So you're questioning the current waiver. You don't think they're entitled to the current waiver? Well,
the waiver is something that's granted on an annual basis, and the administrator would be responsible for making that decision.
Yeah, and so you say you're going to review it?
Yes, Senator.
Yeah, and when you say review, I hear undo, the rights of the states. And I think to a certain extent it's troublesome because obviously what we've heard all day is how much you support states' rights when it comes to these issues. But now when it comes to the right of California, of Massachusetts, and other states to be able to reduce carbon pollution, you're saying you're going to review that. So my problem really goes to this double standard that is created, that when you sue from the Oklahoma perspective, from the oil and gas industry perspective, and you represent Oklahoma, you say they have a right to do what they want to do in the state of Oklahoma. But when it comes to Massachusetts, or it comes to California, and it comes to the question of those states wanting to increase their protection for the environment, protect their victimization from carbon pollution, you say there, you're going to review. And I think that the history of the agency in granting reviews that have been necessary for Massachusetts, for California, and other states to improve the environment are still valid. The science hasn't changed. The new clean energy technologies have not changed. The danger to the public from environmental exposure to carbon pollution has not changed. And so from our perspective, you know, from my perspective, I think it's going to lead to you undoing that right of the states to be able to provide that protection.
Thank you, Senator Mark. I'm going to introduce for the record a report from the National Energy Assistant Directors Association. These are the state officials who oversee the financial assistance programs for people to heat their homes. The report says that when energy prices go up, the higher energy prices result in 24% of the recipients who go without food for at least a day, 37% go without medical or dental care, 34% didn't fill a prescription, and 19% had someone in their home become sick because the house was cold due to increased energy costs. Senator Ernst.
Thank you, Mr. Chair. And again, Attorney General Pruitt, thank you for being here today. I would like to go back to something that a colleague, Senator Duckworth, mentioned earlier today, and that's the point of obligation. The proposal to change the point of obligation under the RFS is an example of a regulatory change that would destabilize the policy environment if adopted. And what's interesting with the point of obligation, we have two sides that normally oppose each other that have actually come together. So both biofuel producers and the American Petroleum Institute oppose this change, both groups. And I would like to submit a letter for the record showing the united opposition to moving the point of obligation. Mr. Chair, if we could have that entered into the record.
Without objection.
And I'd like to revisit this. If you can, yes or no, as administrator, will you oppose changes to the point of obligation?
Senator, as you and I indicated, as I indicated in my meeting with you, and I think in response to Senator Duckworth earlier, there's a comment period in process now at the EPA about the point of obligation. I think prejudging, the outcome of that process at this point is unwise. I can say to you, as I said to you in the office, any steps that I would take as EPA administrator with respect to any issues as far as the RINs program, the monitoring that program, point of obligation, all these various issues that we discuss, the job of the EPA administrator is to make sure that the statute is upheld and enforced and not undermined. The vitality of the RFS program has been defined by Congress dating back to 2005. Any steps that the EPA administrator takes needs to be done in such a way to further the objectives of Congress in that statute, not undermine the objectives of Congress in that statute.
Well, I do appreciate you being objective, and I'm sure that Senator Duckworth and I will look forward to continuing to educate you on those issues. So thank you very much. I would like to show a chart of the state of Iowa, and I would like to go back to some of Senator Cardin's comments about who should define what the expanded definition of waters of the U.S. is. So this is a chart of the state of Iowa, and as you can see, with the expanded definition as provided by the EPA, 97% of the state of Iowa is now considered waters of the U.S. So if you are in an area like mine, southwest Iowa here, right down here, I live in a water of the U.S. Most of the state is covered by the waters of the U.S. And I bring that up because in a moment, am going to show you another picture of the consequences of the EPA defining what a water of the U.S. is. Last Congress, this committee examined the scope of the Federal Clean Water Act jurisdiction EPA and the Corps of Engineers claim today, even without the new WOTUS rule. The committee found that EPA and the Corps are already expanding their jurisdiction using the concepts that they codified in WOTUS. They are just doing it by a case-by-case basis. The jurisdictional claims that are already being made are very troubling. For example, the Obama EPA told the public that they will not regulate puddles. They will not regulate puddles. However, we learned that the Corps is already regulating puddles by claiming that a puddle in a gravel parking lot is, in quotes, a degraded wetland. A degraded wetland. The Obama EPA also told farmers not to worry about being regulated because ordinary farming activities have a statutory exemption. we learned that the Corps of Engineers and the Department of Justice have decided that plowing is not an ordinary farming activity. Explain that to my dear deceased grandfather and my father, whose activities in farming include plowing. According to the Obama administration, any plowing that pushes soil into furrows is not an exempt farming activity because the tops of plowed furrows can dry out. According to a brief filed by the United States, in quotes, the furrow tops now serve as small mountain ranges. Right there, folks, small mountain ranges. These furrow tops now provide conditions that are not conducive to growth and development of wetland plant species. They are mini uplands, end quote. This is a picture of these small mountain ranges from the government's expert report. Mr. Pruitt, will you commit to me that if confirmed, EPA will work with the Corps and DOJ to make sure that federal agencies stop trying to regulate ordinary farming practices?
Yes, Senator.
Thank you for that very concise answer. Thank you, Mr. Chair.
Thank you, Senator Ernst. Senator Duckworth.
Thank you, Mr. Chairman. Mr. Pruitt, I just
Yes,
want
Senator.
I want to come back to this question again, and let me just tell you, I played second base as well. This is, you know, this is a hanging curveball. You can knock this out of a park with a yes, all right? Will you commit, yes or no, to reversing the EPA's current interpretation that available infrastructure should limit the requirements to blend biofuels into our fuel supply, given that it runs counter to congressional intent?
I will not take any steps to undermine the objectives and the statute of the RFS as administrator, as EPA.
So are you committing, will you commit to opposing any attempts to move the point of obligation from the farmer, the soybean producers, the corn producers, and biofuel manufacturers away from them and towards the blenders? Because that would be counter to congressional intent.
Senator, that is something, as I've indicated, there is an open comment period on that very issue. And if confirmed, I would be dealing with that issue and need to respond to the comments that have been made as part of the record. It would be unwise to prejudge that outcome. I can say to you that any steps that I would take as administrator would be in furtherance of the RFS and not to undermine the RFS.
But the comment period has nothing to do with congressional intent. Earlier today, you said that you would abide by congressional intent, that the congressional intent is to keep that point of obligation with the soybean and corn producers and the biofuel manufacturers, not to move away from it, regardless of what the open comment period says. So you're saying that you're willing, that your answer is no, because you would be open to moving it away from the soy and soybean growers, the farmers, towards the blenders, if that's what the comment period says. If that is what comes out of the comment period, is that what you're saying? And that would be against congressional intent, though.
Senator, I think maybe with respect to congressional intent and the statute, the intent as far as the point of obligation is not addressed in the statute itself. That is a decision, and the administrator has been involved in that process historically. It's been subject to much discussion. In fact, the EPA has dealt with this issue before. What I'm saying to you is, it's the job of the administrator to enforce the program, to administer the program, to ensure that the intent of Congress as far as the RFS is upheld. I will do that. To prejudge the outcome of that particular comment period is something that I can't do and shouldn't do at this point. I would need to respond to that only after being confirmed and going through the rest of the process.
So you're saying that you would be open to moving the point of obligation away from the corn and soybean producers and the ethanol manufacturers?
I'm saying,
if that is what if that is what the open comment period says, if that's the result, then you would be open to moving it away from the farmers.
no, I'm saying, Senator, that any actions taken as administrator that would jeopardize and endanger the RFS as intended by Congress, I would not take. That is different from prejudging an outcome in that particular matter.
But the intent of Congress is to keep the point of obligation with the producers.
That's something I'm not aware of, Senator.
Okay. Well, let's move on to, I'm very concerned, and we'll follow up with this in the future. Let's go to safe drinking water. I sit on Oversight and Government, I sat on Government Oversight Committee in the House, where in a bipartisan manner, we explored what happened in Flint, Michigan. And I was actually flabbergasted earlier today when, in response to my colleague, Senator Cardin, whether you believe there's any safe level of lead that children can consume, you responded by saying, and I quote, "Senator, that is not something I've reviewed or know about. I believe there's some concern, but I've not looked into the scientific research on that." You're about to become the EPA administrator. You're seeking to be the EPA administrator, and you've not looked into the issue of lead in our drinking water supply. I think that is something, especially in the aftermath of Flint, is a serious oversight on your part. Have you even studied the Flint water crisis in preparing for this hearing? And do the names Mary Gady and Susan Hedman ring a bell to you?
The situation in Flint, as I indicated earlier, EPA should have acted more expeditiously in responding to Flint, and did not. There was indication at the regional level that there were concerns, and there was not a response. And I think that the EPA bears responsibility for what happened in Flint, and would seek to, in the future, avoid those kind of situations by being more proactive through the regional administrators and the states and municipalities in ensuring the quality of our drinking water.
As EPA administrator, will you commit to appointing a permanent regional administrator to the Midwest region? They'll be based out of Chicago, but they cover Michigan. We have issues with lead in Galesburg, Illinois, for example. And will you give them the responsibility and the ability to act proactively so that they can step in when they see that the state is not doing its job in protecting the safe water drinking supply for its citizens?
As you know, Senator, the EPA, the answer is yes. The EPA has emergency order authority to respond to situations like you described. And I think the EPA should step in those situations in a very meaningful way.
That's good news, because they did not do it in the case of Flint. Thank you. I'm out of time, Mr. Chairman.
Thank you very much. I would like to introduce for the record an article from the Oklahoman by Rick Green, and to read it says, J.D. Strong, Director of the State Wildlife Conservation Department, says of Attorney General Pruitt, quote, Attorney General Pruitt has been a really good partner and ally in making sure we have adequate protections in place for the quality and quantity of water, said Strong, who previously led the Oklahoma Water Resources Board and was State Secretary of the Environment. I have never seen him put us in a position where we had to compromise anything to protect the waters of Oklahoma. Senator Bozeman.
Thank you, Mr. Chairman. And I want to go through, again, I was the congressman in the district with the Arkansas, Oklahoma, Illinois River situation. I was elected in a special election in 2001 and inherited this. This had been going on for about 10 years. In 2001, from that time on, until recently, we probably worked on this, it seems like every week. But what happened was in 2003, the EPA came out and said that the standard was such that by 2013, the river needed to have attainment of 0.037 standard of phosphorus. Arkansas worked very, very hard, changed out all of its treatment plants in that area. That's one of the fastest growing areas in the country. Again, you know, the ratepayers paid for all that, hauled out chicken litter and all of those kind of things, and made a dramatic improvement in the attainment. The problem was, though, Arkansas, and you mentioned, again, my good friend, Senator Booker, and he is a good friend, mentioned a lot about Oklahoma, this and that. Arkansas never agreed to any of that. So they were going forward, but they felt like they could not obtain the 0.037 standard because the first national river is in Arkansas, the Buffalo River, and it was not at 0.037, and it's pristine. So we went with good faith. In 2010, in 2005, I believe, the Attorney General in Oklahoma sued Arkansas. That was, and you can correct me if I'm wrong on some of these things, but in 2010, that case was all of the stuff was put in place, but the federal judges never ruled on it, so it was open. We fast forward, 2013 is arriving. Arkansas still not agree that the 0.037 standard is the appropriate one, so they were squaring off, getting ready to sue each other again. And Attorney General Pruitt, Attorney General McDaniel, a Democrat in my state, got together and said, hey, you know, let's not waste a ton of money with lawyers. Let's, you know, use science and things like this to figure this out. So they chose a neutral site, Baylor University, which has an excellent water department. They came in, did a study, and then came back and said 0.037 is the standard. And right now the states are living with that. So it really was, it was a tremendous effort, took a long time, and it was a very, very difficult situation. So, you know, I applaud you. I want to put in the record a letter from our former Attorney General, McDaniel, that again outlines this and was very, very complimentary of the Attorney General.
Without objection.
Thank you. Let me just quote one of the final paragraphs. Recent press accounts regarding these efforts unfairly mischaracterized the work that was done by General Pruitt and his team. He was a staunch defender of sound science and good policy as appropriate tools to protect the environment of his state. I saw firsthand how General Pruitt was able to bridge political divides and manage multiple agency agendas to reach an outcome that was heralded by most credible observers as both positive and historic. And I think, again, as somebody that was intimately involved in that, more involved than I wanted to be in things, that it really was a heroic effort by yourself and the people in Arkansas trying to resolve, you know, a difficult situation.
Thank you, Senator.
Thank you. That's really all I have, Mr. Chair.
Thank you very much, Senator President. Senator Sullivan.
Thank you, Mr. Chairman and General Pruitt. I wanted to focus on, I talked earlier, a number of us talked earlier about the frustrations that the American people have with the EPA. We talked about anger. Senator Ernst talked about fear. I believe it extends to a couple reasons underlying that. One is the agency currently feels that it's empowered to regulate literally every nook and cranny of American life. And related to that, they seem to have very little respect for the rule of law. So let me touch on those. Senator Ernst talked about the WOTUS rule, and literally the EPA's claimed the ability to regulate puddles. As a state with pre-WOTUS, by the way, 65% of America's wetlands in Alaska, we have very significant concerns about this. But I wanted to actually address an earlier comment by Senator Whitehouse, where he said that there's nothing in your record that shows that you have the background to help America's fishing industry. Well, I couldn't disagree more with Senator Whitehouse, who's a friend and colleague. My state has a fishing industry like Rhode Island's. It's a little bigger. 60% of all the
Stipulate
seafood.
that it's considerably bigger.
Thank you. Mr. Chairman, would you please acknowledge that for the record?
With no objection.
Almost 60% of all seafood harvested in the United States comes from the waters of Alaska, and it's considered the best, most sustainable, best managed from an environmental standpoint fishery in the world. And you know what the #1 issue, the top issue of the fishermen of Alaska is? EPA overreach. So let me give you a specific example. This is a regulation, it's 200 pages, on America's fishermen, the ultimate small businessmen and women. This actually requires, every fisherman in Alaska, commercial fisherman, requires a discharge permit to literally hose off the deck of a ship. Think about that. If you're gutting a fish and fish guts or pieces of a fish fall on the deck of your ship and you hose it down, fish back into the water of the oceans, you need a permit. 200 pages. This is the kind of thing where the trust between Americans and the EPA has eroded so much because of these kind of issues. If confirmed, will you work with me and others on this committee to make sure that these kind of regulations are balancing environmental needs with jobs that are so important? You've mentioned it as a cost. Will you work with us on that? And would you care to comment on a regulation like this? fish back into the ocean requiring a permit. Congress, by the way, has extended this twice, meaning tried to, the implementation of this. So there's bipartisan agreement that we need to do something about this overreach. Would you care to comment on this?
Senator, I think it's exemplary of a lack of priority. I mean, we have many, like indicated earlier, 40% of our country is in non-attainment under the NAAQS program. We have over 1,300 surplus sites in this country that need attention to move those areas into remediation and restore those areas for environmental related issues. And so I think in some respects what you cite there is just missed priorities of trying to focus on something like that as opposed to focusing on these other areas that will really improve tangibly the environmental protections for our people across the country.
Let me talk next about the rule of law, and I'm glad you emphasize it as a priority. I believe it's really one of the principal reasons why, again, there's such a lack of trust between the American people and the EPA. But it's not just a Republican issue. As a matter of fact, there's a number of examples where this is viewed as a bipartisan issue that we need to address. You may have seen with regard to the Clean Power Plan, Lawrence Tribe, not known as a strong, staunch Republican, Harvard law professor, stated, the EPA is attempting to exercise lawmaking that belongs to the Congress and judicial power that belongs to the federal courts. EPA is attempting an unconstitutional trifecta, usurping the prerogatives of the states, Congress, and the federal courts all at once with its Clean Power Plan. Then he stated, burning the Constitution should not become part of our national energy policy. You've been involved in some of these cases, the Clean Power Plan, the waters of the U.S. In both of these cases, courts have stayed the EPA's rule. Why do you think that the courts have done that, and do you think the rule of law that has been ignored by the EPA is something that you need to, if confirmed, that you will work on to regain the trust between the EPA and the American people?
You know, as I indicated, Senator, earlier, I think at times perhaps those in law and the courts, they look at rule of law as something that's academic and technical, but it's real. It affects people in very real ways. When you have agencies of any type that act inconsistent with the statutory authority given to them by Congress, it creates the kind of uncertainty that you're talking about. People don't know what's expected of them, and paralysis happens. And so rule of law is important to economic development. It's important to send messages of certainty. It's important so that people can plan and allocate resources. There are many laws that people look at and say, well, I don't really like that. But so long as they know it's expected of them, they can plan and allocate resources to comply. And I think that's what's important about rule of law.
And as one of the lead litigators on the WOTUS rule and the Clean Power Plan, and the fact that the Supreme Court and the Sixth Circuit have put stays on those rules, what do you think that indicates the court's view is of those two rules issued by the EPA at this moment?
Well, it's unprecedented for the Supreme Court to have done what they did in the Clean Power Plan.
Never happened in the history.
Never happened in the history of jurisprudence before the U.S. Supreme Court. That says a lot.
Thank you, Mr. Chairman.
Thank you very much. Senator Moran.
Mr. Chairman, I'd yield to somebody ahead of me if they'd yield back to me for the next question.
That would be fine. I have some time that I haven't gotten to yet in this second round, and we will go shortly to a third round. I wanted to talk about a little about the Mercury rule that the Supreme Court overturned. They overturned the EPA's Mercury rule, the finding that the EPA did not appropriately consider the costs of the rule. Noting that between the time that the rule was issued and the Supreme Court decision, 3 years passed. The EPA Administrator, Gina McCarthy, was on a television show a couple days before the Supreme Court made its ruling, and they said, well, what if the Supreme Court says you were wrong? And essentially, she said, well, the majority of the power plants have already decided and invested in a path, because it's been 3 years, to achieve compliance with the mercury air toxic standards. In other words, she had already gotten her result, even though what she had done was found by the courts to be illegal. So I'd ask you your thoughts on her statement, and do you believe that her statement shows respect for the rule of law?
Well, Senator, this is speculation to a certain degree, and one of my favorite philosophers is Yogi Berra, and he says that predictions are pretty tough, particularly about the future, and so I don't want to be too speculative here, but when you look at the response of the Supreme Court and this Clean Power Plan, I think largely the reason they acted in an unprecedented way is because of what you just addressed. Mr. Chairman, that in response to the Michigan v. EPA case, there was some comments made that they had achieved the outcome despite the fact that they acted inconsistent with the framework under the law. So I think rule of law is something, as I indicated to Senator Sullivan, is not something that's academic. I think it's meaningful. It inspires confidence in those that are regulated. It gives them assurance that regulators are acting consistent with their authority and allows them to plan and allocate resources to meet the standards and meet the objectives that Congress and regulators establish.
Senator Moran.
Mr. Chairman, thank you very much. General, you can see by where I sat on the dais that I haven't been in the Senate a terribly long time, but one of my causes upon my arrival and discovery of how the Senate works is to try to work with my colleagues to reassert congressional authority. And in my view, there's a number of ways we could do that. One, Congress could quit passing huge pieces of legislation and delegating authorities to agencies and departments. Another one that we could pursue, and I hope we will this year, is an appropriations process by which we have the opportunity to influence decisions made at the Environmental Protection Agency and every other agency and department. And one of the things that, and we do that by developing a relationship with an agency head, knowing that, and I guess part of that is that members of Congress need to become have greater levels of expertise on the subject matter of their jurisdiction. One of the subcommittees I chair is in the Commerce Committee, and it has jurisdiction over the National Highway Traffic Safety Administration. The Environmental Protection Agency just last week finalized its greenhouse gas standards for light-duty cars and trucks for 2022 to 25. Now, the law says that it's to coordinate that effort with the National Highway Traffic Safety Administration, and that agency is still developing its own process to determine appropriate fuel standards. I raise this as an example of where, once again, two agencies instructed by Congress to work together to find a solution or the right answer to an issue ignore the law. I assume you would assure me or members of this committee that the Environmental Protection Agency, to the best of your ability, will obey the law, but I also assume that you are willing to assure me that when directed by the law to cooperate with other agencies, to have the input of an agency that our subcommittee has jurisdiction over. As a person in the Senate responsible for these issues, I go to the agency that I have the most influence over, and they say, well, the EPA's already done its thing. I assume we can bring those kind of practices to an end?
Absolutely, Senator. I think that interagency discussion, that collaboration to ensure that there is meaningful discussion, review of action takes place. I want to speak generally to your delegation reference because I do think that that is a very important issue that you raise. I think a lot of times what has happened is that Congress has spoken in very general ways. I'll not say vague, but approaching vagueness and giving carte blanche or substantial authority to agencies without providing the kind of framework that's necessary for them to make their decision. From a separation of powers issue, I think that's very important. I think it's important for Congress, Article 1, to exercise its authority and to give the direction to these agencies on how they should conduct their business. Senator Cardin, in his comments and questions earlier about the Waters of the United States rule, I think that is a problem presently, largely because the definition of Waters of the United States in the statute is so vague and so general, it creates uncertainty. And so I think making sure that Congress performs its role and the executive branch perform its role in enforcing laws, and we try to do less delegation and respect separation of powers is very, very important.
I appreciate your reassurance of how you would conduct, if confirmed, the agency. It also is a reflection upon the need for Congress to do its job better, and perhaps, I guess you'd have nothing to do that, but for me and my colleagues, we need to be much more precise and clear in legislation and much more likely to deal in smaller bite-sized pieces so that too often I think Congress is interested. I don't want to be derogatory to any of my colleagues, but too often we look for the headline that we've solved a problem, and yet we complain about what an agency's decisions are, and we've given them so much authority they have the ability to make what I would consider, or some of us may consider, a bad decision.
And there are important steps that have been taken. We've mentioned Tosca this morning, where you've done just that during this past year. And so I think that that's a very important item that you raised, Senator.
Thank you. Thank you, Mr. Chairman.
Thank you very much, Senator Mayor. We'll now move to a third round of questions. And Attorney General Pruitt, you just mentioned Tosca. You sent a letter to this committee in April 2015 supporting the Frank Lautenberg Chemical Safety Act. In fact, the timing of your letter was less than a month after the bill was introduced, and you were the first Attorney General in the United States to support the bill. The bill ultimately received overwhelming bipartisan support in Congress. It will be your job to implement the bipartisan reforms and ensure we have consistent regulation throughout the country. Would you discuss the plans that you might have to implement this legislation, and will you commit to implementing the legislation in a timely manner?
Senator and Mr. Chairman, yes. I think in response to the obligations of the EPA, this body has put timelines before the EPA to carry out certain rulemaking, the prioritization rule, the risk evaluation rule, fees that need to be established. All those are midterm in 2017. And I think it's a matter of the EPA administrator making that a priority at the agency. I also think that in response to Senator Gillibrand earlier, and others have raised this too, there are certain, like PFOA, that need to be addressed in evaluating that listing under TSCA or perhaps the Safe Drinking Water Act as well. And so I think there are specific actions that need to be taken, but also the rulemaking process and the deadlines being adhered to.
You made reference to, and I did in my opening statements as well, to Flint, and there was a give and take on Flint a little earlier. The other thing I brought up was the Gold King mine spill in Colorado, an environmental disaster caused by the EPA. Last Friday, the EPA announced that it has denied all claims for the $1.2 billion in lost income, loss of use of property, and damages to the businesses and the property suffered by 73 tribes, by landowners, local businesses, local governments as a result of the spill. The EPA's excuse was its legal interpretation of the Federal Tort Claims Act. According to the EPA, if a federal agency hurts someone through a discretionary action, then the Federal Tort Claims Act does not apply. This doesn't sound right to me. So if confirmed, will you commit that you'll review that decision and use whatever authority is available to you under the law to help the people that have been harmed by the EPA's negligence?
Yes, Mr. Chairman.
Thank you. Senator Carper.
Thanks very much. A question, Mr. Chairman. I know you did not use, when you had you started this round of question, you did not use like 2 minutes and 30 seconds of your time. And when you comment like you've just commented, are you drawing down on that 2 minutes and 30 seconds?
I think I just, yeah, I'm now in the third round of questioning. Yes, sir.
All right.
And then I would reflect the fact that looking back at EPA nomination hearing processes, when Gina McCarthy was nominated, it came to this committee, Chairman Barbara Boxer, 2 rounds, first round 5 minutes, second round 2 minutes. We're now in a third round of 5 minutes, so I think that the chairman has tried to listen to our discussions and with other members to make sure that all the Democrats and every member had a chance.
Thank you for that
many questions.
Clarification. Thank you. I want to go back to something was said by one of our colleagues with respect to EPA actually visiting states and participating in meetings in those states with respect to the combined power plan. I think it was said that maybe West Virginia, my native state of my friend from West Virginia, was not visited. We've heard since then from Joe Goffman, who's the counsel to Janet McCabe. Janet is the EPA Assistant Administrator for Air, as you may know. And he said he personally participated in meetings on a clean power plan in West Virginia, also in Kentucky, Florida, Texas, Pennsylvania, Nevada, Washington, Oregon, California, Wyoming, North Dakota, Colorado, Illinois, and I think Nebraska. I wrote a letter to Gene McCarthy on January the 11th. You may recall, Mr. Pruitt, I wrote a letter to you, I think on December 28th, and posed a series of questions to you and asked for your responses by January the 9th, and I have yet to receive those responses. And I wrote a letter to her on January the 11th, to Gene McCarthy and to Assistant Secretary Darcy of the Department of the Army. And I wrote because we're hearing on our office a whole list of assertions about the waters of the U.S., and I think this is maybe instructive for all of us. Here's things that we were hearing in our office. People just calling in. in Delaware, and led us to ask these questions. One of the questions was, are the EPA and the Corps currently implementing new clean water rule? And the assertion was that, indeed, that's been happening. So we asked, is that really the case? And 2 days later, we received the response, no, the agencies are not now implementing the new clean water rule. Implementation of the new rule was temporarily stayed by the Sixth Circuit Court of Appeals. In September 2015, the agencies immediately directed their field offices to stop using the new rule and instead resume implementing regulations and interpretive guidance prior to the new rule. That was one of the questions we asked. We also asked, because we're hearing assertions otherwise, are the EPA and the Corps currently pursuing enforcement actions pursuant to the new clean water rule? And we got on the same date, January 13th, this response said, no, the agencies are not pursuing any enforcement actions pursuant to the new clean water rule and will not enforce this rule unless until the Sixth Circuit Court of Appeals stay is lifted. Next question we asked, because we're hearing assertions otherwise, does anything in the Clean Water Rule revoke or otherwise modify the Clean Water Act's statutory and regulatory exemptions for farming and ranching? Response 2 days later, January 13th, was no. The Clean Water Rule makes absolutely no changes to normal farming, ranching, and forestry exemptions established under the Clean Water Act and implementing regulations. So, question number 4. Some have claimed that landowners will no longer be able to rely on the Clean Water Act's statutory and regulatory exemptions for farming and ranching should the Clean Water Rule go into effect, because while the statute and regulations remain unchanged, the agency has narrowed those exemptions in practice through the actions in the field. Is that true? And the answer is, not surprisingly, the assertion that the agencies have narrowed application of the statutory and regulatory exemptions for farming, ranching, and forestry is untrue. The agencies have taken no steps intended to reduce the scope of the exemptions, and we have not observed changes by field officers in the way they interpret or implement these exemptions. In fact, the Corps has reemphasized publicly that these exemptions are self-implementing. Farmers, ranchers, and foresters are not required to get approval from the agencies prior to using the exemptions. I raise this because sometimes what people assert to be true, sometimes it's over the internet, sometimes it's on television, sometimes it's on the radio, newspapers. Assertions are made. And in this case, there's a whole long list of assertions that are made. None of them are true. They are distortions, untruths about what the EPA is doing with respect to a regulation that was stayed. And I would ask for the record, Mr. Chairman, to be able to submit for the record the questions that we posed to EPA on January 11th, and also the responses that we have received.
Without objection.
Thank you.
Senator Inhofe.
I'm not through.
Oh, I'm sorry. I think I said thank you. Go right ahead.
I was thanking you for entering for the record.
All right. There are 23, let's record there are 23 seconds remaining.
Oh, thanks. I'd like to look at a chart, if you don't mind. This is a report card. Can you raise it up? Yeah, thank you. This is a report card that lists 17 counties. How many counties do you have in Oklahoma? 77.
Yeah. Mr. Chairman, can I refer to Senator Inhofe on these questions? Yeah.
I was watching. His lips are barely moving when you speak. So.
It's right here, too.
All right, thank you. At the same time, you've been suing EPA on its ozone standards, all the counties in Oklahoma, for which data is collected, earned an F from the American Lung Association for not meeting ozone health standards. You got 60 counties that we don't have. American Lung Association doesn't have data on progress made or not made with respect to ozone. These are the ones we have information on. 17 counties from Adair to Tulsa. You live in Tulsa, I suspect, right? Tulsa County. Yes. They all got Fs. They got Fs. This is last year, 2016. My question to you is, what did you do about it? What did you do about it before or since?
Senator, two things. One,
sometimes people will believe what we say. They may not believe what we say, but they'll believe what we do. What have you done about this?
Yeah, so Senator, two things. I really believe there needs to be a tremendous effort made by counties across this country to move non-attainment into attainment. Over 40% of the country, or presently 40% of the country approximately, is in non-attainment. And there needs to be great prioritization with the EPA and local officials at achieving attainment. Secondly,
no, that was not my question. My question, Mr. Pruitt, was what did you do about that? You got 17 counties on which they have data from last year. What did you do about it, before or since? That's why I'm asking you.
As I've indicated, as indicated in our meeting individually, the primary enforcement responsibility in Oklahoma with respect to air quality permits and the rest is the Department of Environmental Quality. And there have been actions taken by DEQ, and they continually work with those counties to reach attainment. And we provide general counsel advice to that agency in the performance of their role.
I'm not the Attorney General of Delaware, never had an intention to be, but if 17 of our states, 17 of our counties in Delaware, we only have 3. But if 17 of them, or all 3 of them, got Fs, I promise you, I would do something about it. Thank you.
Senator Inhofe.
Thank you, Mr. Chairman. Congress recently passed a bipartisan bill. Many of us up here supported it. I know I did. As part of the water infrastructure bill to allow states to lead implementation and enforcement of EPA's coal ash rule through the state-based permit program. That rule is already in effect, and it's important that the EPA move quickly on this. If you are confirmed, you're going to get right on this thing?
Yes, Senator Inhofe.
All right. Sue and settle, we all know what that is. We know that groups, maybe some of the environmentalist extremist groups, will file lawsuits and against the EPA. The EPA, instead of defending against the lawsuits, will enter into a resolution behind closed doors without any public input or participation. These settlements result in new sets of legally binding priorities and duties for the EPA that achieve the demands of special interests. Can you share your thoughts on sue and settle?
Senator, this issue came up earlier, and it's a concern because it's regulation through litigation. And anytime that there's a place for consent decrees in our litigation system, but to use a consent decree to bypass Congress, bypass the regulatory requirements that you've placed upon those agencies to engage in rulemaking through litigation is something I think should not occur.
And that's the part that did not come up earlier, and I appreciate that very much. And then lastly, the cost of regulations. As you know, the Supreme Court overturned EPA's mercury and air toxics, that's Matt's rule, in 2015 because the EPA failed to ignore the fact that the cost was $9.6 billion annually of the rule. Now, in fact, the EPA's regularly issued rules over the past 8 years that are very costly for our industries and our job creators. According to the CRS, now CRS, when they make an evaluation, are much more conservative. The figure is always a very conservative figure. But they said the Clean Power Plan, it would be at least $5 to $8 billion a year. The figures I've heard on that are far greater because it wouldn't be that much difference than the old system that they tried to do through legislation. The methane standards on oil and gas facilities, $350 million a year. The new ozone standards, $1.4 billion. The 2015 coal ash standards, $587 million a year. And the 2011 sulfur dioxide standards, $1.5 billion a year. Now, when you hear this, all this money is being spent for on compliance costs by our job creators, people out there that are working for a living and they're hiring people. What are your thoughts, and what do you believe should be the role of the cost of EPA's decision-making?
I think it's very important in the rulemaking process, Senator, and the Supreme Court and courts have recognized that very important factor. I mentioned earlier the case that we were involved in Oklahoma involving the Regional Haze Program. That was an example where Oklahoma actually complied and met and satisfied the requirements under the statute and the rule, but their steps that were taken were displaced by the EPA, adding hundreds of millions of dollars of cost to consumers in the generation of electricity. And so costs are very important, and we need to make sure that that they're considered. In certain areas of the statute, as I indicated earlier, they can't be under Title I the NAAQS program. But in that case that you're referring to, it was an obligation of the EPA to actually engage in a cost-benefit analysis, make a record before it made its decision.
Yeah, do you think that the laws that are on the books right now adequately handle this situation?
I do largely, Senator. I think it's mostly an application issue. The agency and the regulator doing its job under the statute is provided by Congress.
Mm-hmm. Thank you very much.
Senator Whitehouse.
And presumably, Mr. Pruitt, it goes without saying that if the EPA is going to consider costs to the industry of conforming to pollution guidelines, it should also consider benefits to the public from cleaner air, cleaner water, and the results of that compliance,
It should.
correct?
It should, Senator.
So we have been talking about fundraising done by you for the Rule of Law Defense Fund during the time when you were both a board member and for a full year the chairman of the Rule of Law Defense Fund, and the fact that we have exactly zero information in this committee about that fundraising. We also have zero, and let me ask unanimous consent for the page from
Without
Pruitt's
objection.
filing that discloses that he was, in fact, member of the Board of Directors and chairman of the Rule of Law Defense Fund. We also have a meeting agenda from the Republican Attorney General's Association during a time that you were executive committee member of the Rhode Island Attorney General's Association, meeting at the Greenbrier, which I will stipulate for my friend from West Virginia is a lovely place to go. And the agenda, which I'd like to take this page of and put into the record, mentions a private meeting with Murray Energy. It mentions a private meeting with Southern Company. It mentions a private meeting with the American fuel petrochemical manufacturers. If you'll show the graphic, these are all the same groups that I've been asking about in terms of your fundraising for the Rule of Law Defense Fund. And, you know, there's Murray Energy, and there's Southern Company, and I'm sure the American fuel petrochemical manufacturers represent a lot of the others. As I understand it, we know nothing, no minutes, no statements, no reports about what took place in those meetings that are described as private meetings on a sheet that is stamped confidential, correct? We know nothing about the content of those meetings.
Senator, I didn't generate the document. I know nothing about how that document got generated or what.
Are you denying that those private meetings took place?
No, Senator, I just didn't generate the document and don't know about the content other than what you've represented.
Okay, and we don't know. And because you were on the executive committee of RAGA, that's information that we could get, right? I mean, it's available if there were minutes or reports out of those meetings, notes taken, but we don't have them, correct?
Senator, that would be a request made to the Republican Attorney General Association. And I might add, the Republican Attorney General's Association, there's a Democrat Attorney General Association as well.
I'm
They
not
have the same
faulting
kind of
that. I'm
meetings.
talking
So
about
these
private
These meetings take place all over
at
the
a
country.
time that you were on the executive committee with some of the really, really big polluters with whom you've been very closely politically associated.
There's a conference, if I may, Senator, of Western Attorneys General.
I know.
There's obviously the National
And
Association.
they talk
of
about
Attorneys
water.
General.
Drives, that's what they,
And there are meetings that take place at each of those events
the rest
as
of
well.
the attorney generals avoid that because we don't want to talk about water. Let's talk about FOIA. You've had a conversation with the chairman about FOIA. As I understand it, there is a FOIA request to the Oklahoma Attorney General's office, to your office, for emails between your office and Devon Energy and Koch Industries and Americans for Prosperity, the Koch front group, and Murray Energy and the American Petroleum Institute. And the information that I have is that that Open Records Act request was filed more than 740 days ago, more than 2 years ago, that in response to it, your office has conceded that there are 3,000 responsive documents, 3,000 emails and other documents between your office and these companies, and that in 740 days, exactly 0 of those documents have been produced. Is that acceptable turnaround on a FOIA request? And should we not be concerned that your office is not complying with the FOIA request that relates so specifically to so many of these companies that are going to be before you as EPA administrator if you're confirmed?
Senator, I actually have a general counsel and an administrator in my office that are dedicated to performing or providing responses to open records requests. As they're known
Not
in
very
Oklahoma.
dedicated if it takes
And-
740 days.
But
and
I'm
the answer's
not.
still 0.
I'm
right?
not involved in that process. That is handled independently by the administrator and that general counsel in responding. So I can't speak to the timeline and why it's taken that length of time. But I can tell you that our office works. We actually go across the state of Oklahoma through training with with officials locally in compliance with FOIA and open records laws. So there
Well,
are
maybe
individuals
you want to
dedicated
send
to
your
that in our
people to
office.
your own training, because it doesn't seem to be sticking very well.
I'm not sure what the representation you made about the timeline. I don't know. And
Given how many of these groups have important financial interests before the EPA, do you not think that 3,000 emails back and forth between you and your office and them are relevant to potential conflict of interest as an administrator and should be before us as we consider this?
Again, I think the EPA Ethics Council has laid out a very clear process with respect to covered entities, as we've described earlier, and on particular matters and specific cases, I will follow the advice of that EPA career person, ethics, to make sure that there
You keep saying that, but the problem
time
is...
has expired.
Will you finish my sentence?
Please do.
The problem with that is that if you haven't disclosed any of this information, then the EPA Ethics Council would have no idea to even look. They would have no idea what the risks are. You can't say, nobody can look at whether I did this, but by the way, they're going to look at it. It just doesn't add up. Sorry about going over my time.
Thank you, Senator Rice. I would like to point out we had a report card that was just brought up, and I'd like to introduce for the record a letter from each of the 5 members of Congress from the state of Oklahoma with their steadfast support for Scott Pruitt, and saying we are proud of his service to our state and are very confident that he will do a superb job serving our nation and our citizens in this new role. Also, as a follow-up for the first round of questions, there was some dispute about a lawsuit against Mahard Egg Firm and who it was filed by. I have here the complaint in the case, and it was filed May 18th, 2011. And you read it, it says, "And the state of Oklahoma by and through Attorney General Scott Pruitt." So you were the one that filed the suit, along with the Attorney General of Texas against Mahard Egg Firm, and this will be submitted for the record as well. Senator Capito.
Thank you, Mr. Chairman. Since the ranking member mentioned that Mr. Joe Goffman had visited, I called to the attention in beseeching you that when you are successfully the administrator at the EPA, that you will listen to everybody and come to states that are most directly affected. He mentioned that the associate assistant administrator had made the long list that he had said. But I'd like to point out clarification. The EPA announced on September the 30th, a day I'll remember because that's the birthday of my youngest child, and they announced where they were going to be going for their listening sessions. They went to Boston, they went to New York City, they went to Philadelphia, they went to Atlanta, they went to Denver, they went to Lenexa, Kansas, and I wish our Kansas senator was here, which I've looked up as part of the Kansas City metropolitan area. They went to San Francisco, they went to Washington, D.C., they went to Dallas, they went to Seattle, they went to Chicago. My state, in the last 5 years, has lost 10,000 jobs, not wholly because of this, but some of this pays a large part. And so I'll go back to my original request that the people that are affected by this environmentally and health-wise are just as important as the people who stand to lose their jobs over this, who then are plunged into poverty, who then have hopelessness around and in their communities, who then become addicted to drugs and other opioids. I mean, it's just a cascading issue. Their lives are just as important. So that's my plea on that. Now, last question from me.
Mr. Chairman, could I ask a unanimous consent request? If I'm sorry for interrupting, but the docket with respect to the outreach that the EPA did in conjunction with the Clean Power Plan shows from October 16th to 2014, something like this.
After the listening session.
The docket records nearly 1,000 meetings, calls, presentations, conferences, consultations, 1,000, and other outreach with stakeholders. Docket shows these post-proposal interactions concluded more than 300 meetings with state and local stakeholders, about 30 discussions with tribes, 450 meetings with industry stakeholders, 150 discussions with environmental justice and scientific stakeholders, dozens more discussions with conveners, and this goes on and on and on. In total, the agency received almost 4.3 million comments about all aspects of the proposed rule, more than any rule in EPA history, and thousands of people participated in the agency's public hearings, webinars, listening sessions, and so forth, all across the country. The agency made many revisions in the final rule and in response to those comments. Thank you.
And then I'd ask that once a questioner starts to be allowed to continue, because we could get into a lengthy discussion. The EPA was found guilty of covert propaganda for soliciting information through a number of environmental groups. It continues to be a blot on the record of the EPA and a question of the entire administration and their approach toward abilities of toward the rule of law versus an EPA out of control. So we're going to allow the questioner to continue. Can I refer back to you, Senator Caput?
Thank you. Not to beat a dead horse, but to try. I'll say that the Assistant Administrator McCabe, when she was telling me that she's the only one to go where places were comfortable, she looked at me and said, "Senator, we're going to Pittsburgh." Gee, thanks a lot. In any event, which is not in West Virginia, I'll make that point. My question is, you've said a lot about states, and I agree. The states should have the primacy. It's in the law, and that's something that part of why you've brought suit and part of the reasons you've been successful with other attorneys general. Let me ask you a question. Let's say you have a state where you're the administrator of the EPA, and you deem that that state's Office of Environmental Quality, or DEP, which is what it is in West Virginia, just doesn't measure up. They're not protecting their people's health. They're not enforcing the law. They are, in your judgment, and folks that you're working with are not up to the task and are letting their people down. What avenues of correction would you have at the EPA, and do you have, and what would you exercise in that kind of category, and what kind of judgments would have to be made for those things to occur?
Senator, I really appreciate the question, because I think there are times where states are recalcitrant, that they don't perform the obligations that they have, let's say, under the Clean Air Act in adopting a state implementation plan, or as they adopt the state implementation plan, they don't take into consideration all the factors that Congress has put in the statute and the EPA requires. In those instances, it's very appropriate for the EPA to use its authority, like a federal implementation plan, to take over that jurisdiction and to ensure that the safety and health of our citizens is protected and air quality is maintained and water quality is maintained. So there is a time and place for that. I think in many instances, however, the last several years, it's been the first response as opposed to, cooperation, and a federal implementation plan is absolutely in order at times.
Senator Merkley.
Mr. Chairman, before you start my clock, I'd like to follow up on Senator Inhofe's strategy here of submitting certain facts back for the record. And I'd ask unanimous consent to submit for the record an article from the Union of Concerned Scientists related to the so-called climate gate that the Senator referred to earlier. And that notes that the manufactured controversy over emails stolen from the university has generated a lot of heat, but not light. The email content being quoted does not indicate climate data and research have been compromised. Most importantly, nothing in content of these stolen emails has any impact on our overall understanding of human activities driving dangerous levels of global warming. Media reports and contrarian claims that they do are inaccurate. And so I submit that
without objection
for the record. Thank you. I'd also like
Mr. Chairman, since my name is invoked, let me respond. Were you listening when I talked about the various publications that have come and talked about how fraudulent it was? These are publications, science publications, that have gone in and made their own evaluations. And for the UK Telegraph to say it's the worst scientific scandal for our generation, then that's pretty extreme. And
my colleague, we could have an entire day dedicated to the review of the scientific literature on this, and it would weigh very heavily on the scales and the direction I've indicated in support of the information presented by the Union of Concerned Scientists. We may just have to agree to disagree. That's why I'm submitting it for the record. We'll let the public decide.
And that's why the statement is repeated over and over again about the science is settled is not an accurate statement.
I invite the Senator to question the witness.
The beauty of the Senate is we get to have our own opinions. Meanwhile, I also wanted to submit for the record in response. So when I was speaking about asthma, Mr. Chairman, you noted a study from the National Black Chamber of Commerce. And it's important to note that organization has been funded by the American Petroleum Institute, by a Koch brothers front group, and by Exxon, and that there is a series of responses that invoke the opposite side of that, and the NAACP, which certainly speaks for a broad swath of African Americans, takes a very, very different stance, and it has endorsed the Clean Power Plan.
Without objection.
Thank you. I'd also like to submit for the record 2 articles or 2 statements from the National Congress of American Indians and from Latino organizations, a whole group of Latino organizations that are very concerned about this nomination.
Without objection.
Thank you very much, Mr. Chairman. And then I'd like to turn to a question that has puzzled me over time, and it's in the context of how one evaluates how one views the world. And I heard one of my colleagues once present it this way: if you go to a doctor and they say you have cancer, and you decide you better get a second opinion, and then you go to 100 doctors and 97 of them say you have cancer and you better act, most people feel like, 97 doctors told me I should act. 3 said I should go take some health care supplement. Maybe I better have the operation. And that's really the place where we are in climate science now, where the overwhelming weight of the scientific community weighs in and says, yes, it's very logical. You can do it in a laboratory, as Senator Whitehouse noted, that carbon dioxide traps heat. You can do it in a laboratory that methane traps heat. You can track the change in the environment of the concentration of those gases. You can see the impacts on the ground now. In my home state, you have an impact on the oysters because the Pacific Ocean is 30% more acidic than it was before we started burning coal. That is a scary thing when shellfish have trouble forming shells. It has an economic impact. Our pine beetles are thriving because the winter's not cold enough to kill them, and so it's having a huge impact on our forests. That's an economic impact on rural America. The southern part of my state has had 3 worst ever droughts in the last 15 years. It is a huge impact on the agricultural community. The streams in Oregon coming from the snowpacks have been declining in size and raising in temperature, very bad for trout, very bad for salmon. That's an impact on our fishing community. So the global warming that is taking place and being driven by the burning of fossil fuels is having a huge economic impact on the citizens of my state, my rural citizens, my citizens who depend on timber, who depend on fishing, who depend on farming. Should the citizens seek to address this problem, because we're just on the front end of this happening. 10 years ago, we were talking about models. It led to the conversation Senator Inhofe had about ClimateGate, about wrestling with assumptions and models. We don't need models now. We have facts on the ground. The moose are dying because the ticks aren't being killed by the winter being cold enough. The fish are migrating on the Atlantic coast, and Maine's losing its lobsters to Canada. These facts on the ground are extraordinarily real. They have a huge economic impact, and shouldn't we take a very serious approach to the urgency of this problem as we see it descending upon us?
Senator, I think the EPA, and if confirmed as administrator, there's currently an obligation to deal with the issue. That the Massachusetts v. EPA case says that CO2 is a pollutant under the Clean Air Act. And as such, that's what generated the 2009 endangerment findings. So I think there is a legal obligation presently for the EPA administrator to respond to the CO2 issue through proper regulations.
I believe you're acknowledging in that, which I'm glad to hear, that it is a serious problem and that the EPA, that carbon dioxide is a pollutant, and we have a legal obligation to take it on.
I think Massachusetts v. EPA says that, counterbalanced by the UARG decision that came out a few years later, that you can't transform a statute as the EPA sought to do with the PSD program. So I think the court has spoken very emphatically about this issue, and the EPA has a legal obligation to respond.
And as you kind of rank the urgency with which you bring to this, do you see it as something that you wake up every day Being, Mike, the next generation will weigh whether or not we acted promptly, or is it more, I have a legal obligation because of this court decision, so I'll have to have some folks pay some attention to it?
I think the important, Senator, it's very difficult to prioritize. You know, Senator Gillibrand's not here, but when she talks to me about PFOA and the threat that she's facing in New York, is that any less important than the CO2 issue? It's not. And so the EPA deals with very weighty issues, as you know, water and air quality. It's a matter of prioritizing the resources to achieve better outcomes in each, and I think it's very important to do so as administrator.
I do feel like perhaps you don't understand the gravity of the situation from your response, because there are feedback mechanisms that are starting to occur with the open blue water in the Arctic, feedback from methane bubbling up from the permafrost, bubbling up from the peat bogs, bubbling up from what was previously frozen methane on the bottom of the ocean that has incredibly accelerating impact on global warming. Our rate of carbon dioxide pollution is not decreasing globally. It has doubled in rate from 1 part per million per year to 2 parts per million per year. So we are on an accelerating curve as a human civilization. And if human civilization doesn't get it together very quickly, we are in very deep trouble. And I would hope that at some point, perhaps the urgency of the situation would be something you'll grab hold of. Thank you.
Thank you. Senator Rounds.
Thank you, Mr. Chairman. Attorney General Pruitt, last year at an oversight hearing, we heard reports of the EPA regional offices who were sending companies information collection requests, or ICRs, pursuant to Section 114 of the Clean Air Act, regarding their operations with no explanation as to the reason for the ICRs. These ICRs, which companies are legally obligated to respond to, can cost the companies millions of dollars to collect the information to respond to the request. They often hear no follow-up from the EPA regarding whether their response was adequate or what the information would be used for. Last year, I requested from the EPA a record of the ICRs that had been sent to U.S. companies throughout the various regions. I was told by the EPA staff that there was no way to get this information because they didn't have it. Second, in 2015, I wrote a letter to the EPA Administrator Gina McCarthy requesting the economic information that forms the basis of the Clean Power Plan and the Ozone NOx standards. These are the major regulations that were being quickly imposed on American taxpayers. The response which I received took 2.5 months to get the response, but I understand that I'm one of the few recipients of an actual letter back from the EPA, and I would ask that it be included as part of the record of the meeting today, Mr. Chairman. And the letter was basically nothing short of referring me to an internet link that directed me to a web page, the same web page which generated the questions in the first place. Essentially, they just simply suggested that I Google it. Not hardly a response that you would expect back from a federal agency, at least one that was trying to be responsive with regard to major proposed rules. Working as a United States Senator, I found it nearly impossible to easily access the information that I'm looking for. I can't imagine the difficulty of a small business, a farmer or a rancher, when they are seeking to get information from the Environmental Protection Agency. As the EPA administrator, the role which you are seeking, do you believe that this is an adequate way to communicate with the public and elected officials? And what are your views on making agency communication and record keeping more transparent and accessible?
Senator, this is actually a common theme. As I met with many of you on this committee, both Democrats and Republicans, it was expressed to me that a concern about the lack of response by the EPA at all in response to inquiries, let alone the time response. And so I believe it's very important, as I indicated in my opening statement, to listen not only to the voices of the American people, but listen to members of Congress, listen to members of this body with respect to the issues that are of concern to them in their respective states. And that's something I take very seriously and would seek to respond expeditiously to you and to others of this body with responses.
The ranking member had asked and was following up with the questions in terms of your role as the Attorney General with regard to fracking issues in Oklahoma, but also with regard to clean air attainment levels and so forth. And it seemed to me that what you were trying to portray at the time, and I'd like you to expand on this because I think this is important, is that you have a different role as an Attorney General than you would be if you were responsible as the agency within the state who had the directed statutory authority to respond to those issues. It seems to me that that's one of the roles that the EPA administrator has, which would be different than that of an Attorney General, which is the execution of the laws that we've passed. Could you expand a little bit? Because I think this is really important in terms of the way you perceive your duties with regard to executing the laws that this Congress has passed.
Yes, Senator, and I appreciate the question. The role of an administrator is to perform an executive role, an executive policy-making role, in carrying out the functions and the statutes that Congress has passed. That's much different than my current role as Attorney General. And as I tried to indicate to Senator Carper, that in respect to enforcement actions in the state of Oklahoma, that's vested specifically in the Department of Environmental Quality. They are the ones that bring enforcement actions against companies who do not comply with air permits, et cetera. We provide general counsel to them in that process, but it is not our responsibility, but more, it's not our jurisdiction. And that's important to me because it goes back to rule of law, it goes back to process. I think oftentimes what we see in this country is that folks kind of disregard the authority or jurisdiction that's been given to them by the statute of the Constitution, and they act anyway. That's what creates, I think, a lack of confidence in the American people. And so I've tried to respect those boundaries. I've tried to respect my role as Attorney General, stay in my lane, if you will, and provide the counsel and perform the job that we're supposed to perform to that agency, but then allow that agency to enforce as required by law.
And then very quickly, that also means that with regard to determining the science behind the laws that we create, as the administrator, you're not going to make the determination yourself. You expect that sound science and that scientists with that background would be making the recommendations that you would then base a decision on?
Yes, Senator, objective and transparent in that process.
Thank you. Thank you, Mr. Chairman.
Thank you, Senator Brown. Senator Booker.
Mr. Chairman, if you gracefully hold the clock for a second, because I want to respond very succinctly to something that Senator Bozeman and you said. First of all, to you, sir, I just want to say it's my first time going through nomination hearings. You have been very generous with the way you've been conducting these hearings. I think it's important that we note that, and I appreciate the number of rounds that you're doing. And then to Senator Bozeman, I really do appreciate him adding to the line of inquiry I'm having. He referred to me as a friend, which means a lot to me. People around here, your colleagues, know that you have a deep respect for the kind of kindness and just decency that you represent. It's a level to which I aspire to but have not attained, so I thank you for that. Thank you for indulging.
Thank you.
And again, with respect to my colleague, who is a really good man, if this was between Delaware and New Jersey, I'm the upstate, I would be very happy with the agreement that it seems that you did, but you are the downstate, and so that's what I don't understand. Now, you said earlier in your testimony in regards to this matter that you have a copy of the 2003 agreement. Do you have that?
I had the second agreement, Senator. The one.
Okay, well, let's just look at the 2000 agreement. And I know you claimed in your testimony earlier that the 2003 agreement had an expiration on it.
There was a 10-year period that needed to be reevaluated. This is the second statement I have here, Senator. I don't have.
Well, sir, I just want to clarify. It seems that that's a contradiction. There's no expiration on the 2003 agreement. It had a reevaluation, a period in which it would be reevaluated, and it was reevaluated by your state with involvement of the EPA and the involvement of Arkansas, and they came up with the same .037 standard. And if you look at the provisions of what you do have in front of you, the 2013 agreement, and I have a blow-up of page 4 of that agreement, it states that, starting here, it states that Oklahoma, through the Water Resources Board, will propose a rule amendment that removes the date to achieve full compliance with the numeric phosphorus criterion set forth in Oklahoma Administrative Code, and then it lists these two codes. And if you look at those two codes, what those two codes do, you know what they are. They set the sections of phosphorus concentration shall not exceed 0.037 by June 30th. It's removing the June 30th deadline in these two statutes. And so that's what is frustrating to me, is that this is what you're heralding as a great agreement, but you already had in your 2013 agreement. What it's clear that you're doing to me, and I don't know other way of reading it in the facts, is you take a binding rule of law and you suspend it for another 3 years, allowing the more pollution to take place.
Senator, that is not, the issue here was not whether Oklahoma could enforce its .037 standard. It was whether Arkansas was going to adopt that standard on that side of the border. That had never taken place in history. That was the concern of Oklahomans. That was the concern of Mr. Fight of the Scenic Illinois River.
And so I respect that. I'm going to stipulate to what you said. I'm running out of time, sir, because I agree with you whether Arkansas was going to be able to live up to that standard. But you're the Oklahoma Attorney General. And this is what I want to say. As soon as you did this so-called historic agreement that set it back, you basically turned to the EPA with the with the power of the law of the Supreme Court and say, okay, back off of my corporations. Why do I say that so confidently? Because I pull a letter from Tyson Foods that literally 6 days after your so-called historic agreement of suspending this rule for 3 years, they're delighted. They write to the EPA and say, hey, you may have now already heard of the February 20th agreement by Arkansas and Oklahoma officials to jointly conduct a comprehensive study of concentrations and impacts in the Illinois rivershed. They're excited. They literally say compliance, however, with the .073 milligram has been suspended. So lay off us, EPA, under this agreement until the study process is completed. They say, in conclusion, the bi-state agreement has suspended implementation date of .037 during the term of the agreement. Industry is really happy about this and believes, in accordance with this letter, unless you're saying Tyson's is wrong, they believe that what you did is give them, the EPA, with the power of the Supreme Court and the 20 years of work that predecessors of yours had done, the power to suspend that power over them to comply with the law. And so that's really what I'm struggling with. On one hand, you say that you file lawsuits against 14 people against the EPA. It's this idea of federalism, Oklahoma's sovereignty, Oklahoma states' rights. You're fiercely fighting for Oklahoma. And on the side of the polluters, and you say the EPA is attempting to do things, but then on the other hand, in this case that you're talking about, you switch suddenly to say, well, Oklahoma's water quality standard for phosphorus that has been worked on for 25 years, armed with an EPA approval, armed with a Supreme Court decision on point saying that upriver states are bound, industries believe that they're bound, but suddenly you're no longer fighting for Oklahoma, you're fighting to protect industry and on the side of industry again.
I can assure you, Senator, that industry didn't think they were bound, and I can.
Then why did Tyson's write the letter, sir?
I don't know. I don't know why they said that, because as Senator Bozeman indicated earlier, the phosphorus level at .037 was unenforceable on the Arkansas side of the border, and that's where the contribution was. That was the concern. And until this agreement that we have here was negotiated and signed by Arkansas, that had never occurred in the history of Oklahoma.
But, sir, Arkansas was party to the 2012 scientific investigation. They're bound by a Supreme Court justice case, which I pointed out to you already, and I could read you the binding paragraphs. It had brought in by the EPA, and obviously understood by industry that they were bound by that standard. Your agreement didn't stop it. It extended the period in which people could pollute. I don't understand how that could be historic.
Senator, I think as you look at what was achieved between Arkansas and Oklahoma, you have the Arkansas Attorney General, Ed Fight, who had been involved in these issues, as indicated earlier, since 1983, trying to enforce and obtain water quality that improved the scenic Illinois River. He cited the historic results in this matter. So I'm unaware of the letter that you're referring to, but I can assure you that industry was not at all excited about .037 being enforced on Arkansas side of the border.
And I'll conclude just by saying, sir, it's clear that industry was excited about the 3-year delay that you bought them to continue to pollute. It's written there in a letter. And it seems to me the theme in your work is not federalism and states' rights, but deregulation and siding with polluters against the environment and the public health standards. And it's unfortunate to me that unless you can show me something different in the way that this actually helped to clean up the river quicker, But I just don't see that at all in the evidence and the facts that I have before me.
Thank you very much, Senator Booker. Our next questioner is actually Senator Bozeman, since we have Oklahoma and Arkansas both here. I don't know if you have a question, Senator Bozeman, or if you just want to make a comment about this agreement that, since both of the states are here, and I think you did represent the congressional district directly adjacent.
No, I want to make a quick comment, and then after that, I think all of my questions have been answered, and would yield back if, if we can have agreement. But I think that the thing, Senator Booker, to understand is that first of all, the water was not being polluted at that point. Arkansas had made tremendous improvement over the years, and had just our discharge in Springdale, Fayetteville, Rogers, Bentonville, the major communities there that have grown tremendously during that time frame. Their discharges were down to very admirable levels. So all of that was being done. The question was .037 fair versus .04 or .05? As I mentioned earlier, our most pristine river in Arkansas was not at .037. So we didn't feel like we could do that. So Oklahoma was happy with all this stuff. Arkansas was not. And because of that, in 2013, as the agreement ran out, they were prepared to sue to go back to court again. This thing had been litigated since the Supreme Court finding back in the 90s, all along the line. But that's, and to be honest, I'm not happy with the .037. I think it's too stringent. I would challenge, to find a river in New Jersey that meets that standard, and you can't do it. It's a very, very stringent standard. So it wasn't continuing to pollute and things like that. Tremendous progress made on the Arkansas side. Everyone agrees with that. It was, where do you draw the limit? And so often with the EPA, and this is so important, we've had on the committee, we've had the gentleman that represents the water district, for this huge area. They spent $1 billion, doing a great job of cleaning things up, raising everybody's rates. EPA has come back and wants them to spend another $1 billion for a tiny fraction that everybody agrees would not have any impact on the water quality in the river. Those are the kind of things that you get into. So again, I'm really not happy at all about the .037. I think that Tyson's in the industry were happy in the sense that you would have a situation where you would have some finality, you would have some resolution, so that everybody could go forward.
Senator Ernst, any final comments or thoughts or questions?
Thank you, Mr. Chairman. I don't have any further questions. Whatever additional questions I have, I will submit for the record. But I do have some closing comments. I do want to push back a little bit on the ranking member's comments earlier. I had gone through a series of examples of overreach by the government with the expanded definition of waters of the U.S. And the ranking member had stated that he had a letter that he'd received from Administrator Gina McCarthy. And I have no doubt that she was answering those questions honestly, because she wasn't the one making the statements. The statements that I presented came from the Corps of Engineers and the Department of Justice. Now, I know this to be true. These are not as implied from some obscure website off of the internet done by some blogger in a basement somewhere. The comments actually came from this committee. Case studies from this committee, September of 2016. These are examples of case studies from all across the United States, and I will cite just one that I opened up to. A landowner in California received an investigation letter from the Corps informing him that disking performed by a tenant farmer on his land may have resulted in an unauthorized discharge into WOTUS, and that regulators had opened a case against the landowner. They are being implemented case by case. This letter came as a surprise to the landowner, who had been disking this particular site periodically over the past 15 years to sustain grazing conditions for his cattle, a practice he believed was normal until he received this notice. The Corps told the landowner's consultant that all disking for any purpose and at any depth with any potential WOTUS is a discharge into WOTUS and, in the absence of a permit, represents an unauthorized discharge and violation of the Clean Water Act. This is an actual letter from the Corps that was submitted to this committee, the EPW committee, last year. So this is not made up. This is a very real impact to all Americans. And so I appreciate your stance, Attorney General Pruitt, that if you are confirmed, you will work with those that wish to continue farming normal practices. But this is not made up, folks, and we just need everyone to understand that the Corps, the DOJ, and the EPA have gone beyond what we consider to be reasonable application of the law. Thank you very much.
Mr. Chairman, if I could just respond very briefly. The letter that I sent on January 11th was not just to the EPA. It was the head of the EPA and also, I think, the Assistant Secretary at the Army, Department of Army, who's in charge of the Army Corps of Engineers. So it was really to both EPA and the Army Corps of Engineers. I gave them a half dozen or more questions and said, these are the assertions that we're hearing. What is the truth? And they responded jointly. So I would just leave it.
And if I can respond to that, I apologize, because I was going to use Senator Round's letter as a prop. I had not seen a letter from the EPA. I had written Administrator Gina McCarthy nearly 2 years ago on some issues that I was wanting addressed for Iowa, and I invited her to come to Iowa and visit. She never, ever responded to me or my staff. So thank you, Mr. Chair.
Senator Markey.
Thank you, Mr. Chairman. Mr. Pruitt, you have criticized the Obama administration on a number of occasions for allegedly, quote, colluding with environmental groups to engage in sue and settle tactics. You just reiterated your concern to Senator Inhofe. But in December, many of your co-plaintiff attorneys general who are suing the EPA over the Clean Power Plan sent a letter to President-elect Trump urging him to settle their lawsuits related to the Clean Power Plan. That sure sounds like an invitation to engage in sue and settle to me. To avoid the appearance of entering into sweetheart settlements on the Clean Power Plan cases, will you commit to recusing yourself from all ongoing litigation that you are involved in?
Senator, I would say to you that the sue and settle practice, whether by this administration or future administrations, is a practice that should not be followed. I believe that regulation through litigation is wrong. I believe that the rulemaking process that Congress has established should be respected by agencies, not only the EPA, but across the board. I would mention one case to you.
Well, this is what the attorney, it looks a lot like that's what the attorneys general are doing who are suing, and you're a co-plaintiff in this case on the Clean Power Plan. Will you recuse yourself from any role in the settling of these cases, in the negotiation on the settling of these cases?
The sue and settle practice should not be used by any administration to regulate. We've experienced in Oklahoma a case involving the Fish and Wildlife and Endangered Species Act in the relisting of the lesser prairie chicken that impacted our state. So sue and settle is wrong. Sue and settle is wrong.
Are you giving me a yes that you will not settle with these attorneys general?
I will not engage in a sue and settle practice if confirmed as EPA administrator.
Okay.
At any time.
So will you negotiate with them to reach a settlement, such as that has been recommended by the attorneys general, who are the plaintiffs in this case against the Clean Power Plan?
Senator, it is a belief of mine that the use of sue and settle is a practice that should not be done by any agency of the U.S. government.
So will you recuse yourself from any involvement in this litigation as it is being decided?
As I've indicated to you, Senator, the EPA Ethics Council, career staff at the EPA has said that a particular matter in a specific case, that those will be evaluated at the time. I'll seek their counsel and comply with their counsel.
Honestly, Mr. Pruitt, there is no bigger case than the Clean Power Plan. It goes to the promise that the United States is making to the world that we are going to reduce significantly our greenhouse gases. So this just goes to you as an individual saying that since you brought the case with these other attorneys general, that you will now recuse yourself from that matter, since you are, in fact, the plaintiff and defendant in this case if you are confirmed as the EPA administrator.
Senator, as I indicated to you earlier, and I'm sorry to interrupt you, but as I indicated to you earlier, I will recuse if directed by the EPA Ethics Council, career staff at EPA Ethics. You know these individuals. They've been there, and I will follow their counsel and guidance.
All right. I know I'm not going to get you to recuse yourself from any of these cases, but I'm just telling you it's going to wind up being a huge conflict of interest if these attorneys general get to settle on their terms with the Trump administration, and you're sitting there in the middle of the room as that occurs. Now, let me go to another subject, and that is this bottle of Trump water. Trump water, natural spring water. On the label, it says, quote, pure, fresh, and free from contaminants. This is water the way it was meant to be. Trump hotel guests have the luxury of drinking this water if they don't trust what comes out of the tap. Low-income communities across our country do not have the same luxury. Do you agree that the EPA plays a critical role in ensuring that all Americans, regardless of racial, ethnic, or economic backgrounds, have a right to clean water free from contaminants?
Absolutely. In fact, Senator Book and I talked about environmental justice in our meeting.
And that is great. As the widespread lead contamination in Flint, Michigan's water supply tragically reminds us, low-income and minority communities often bear far greater environmental burdens. Yet you told Senator Cardin earlier today that you didn't know if there is any safe level of lead. But scientific experts, including the CDC and World Health Organization, have concluded that there is no safe level of lead exposure. Will you commit to making environmental justice for poor and minority communities an immediate priority of the EPA if you are confirmed as administrator?
I believe it's a very important role of the EPA administrator.
Well, minority communities often don't have the money.
The senator's time has expired in the third round.
Okay, thank you, Mr.
Thank you. And Senator Sullivan.
General Pruitt, I just had one final question. We talked about some of the challenges that we have. This committee has been working on the infrastructure issues. There's a lot of discussions over last year about Flint, Michigan, and aging infrastructure, which I think is a concern at the state and local and federal levels. There's also a challenge in certain parts of the country on no infrastructure, none, on clean water and sewer. And my state has over 30 communities that don't have any clean water and sewer in terms of the diseases and the living conditions in communities like that. As you can imagine, it can be very difficult. So in a bipartisan way, this committee acted last year, established a new program for disadvantaged communities, small communities, to work on those kind of issues for different communities, whether in Alaska or other parts of the country, that literally live in third world conditions in some communities. So that would be administered by the EPA, this new program. And I just want to get your commitment to work with us to fully fund that new program to work on those kind of issues.
As we talked about in our meeting, Senator, I believe sometimes when infrastructure is referenced, we think roads and bridges and we don't think water infrastructure. Yeah. And I think all those are important. And I would make that a priority interfacing with Congress if confirmed as EPA administrator.
Great. Thank you.
Thank you, Senator Sullivan. I want to thank all of the members for the respectful way in which the business was conducted today. Members may also submit follow-up written questions, but it seems that everyone had plenty of opportunity to ask oral questions. Scheduled for the recording for the close of business Thursday, January 19th. Senator Carper.
I thought we were going to do one more round.
I thought 3 rounds was the longest in the history of this. The only other time there were 3 rounds was Christy Todd Whitman in 2001, and those were 3 rounds of 5 minutes each. And the reason that she, as a Republican nominee, was given 3 rounds is that the chairman of the committee was Harry Reid. So 3 rounds. The witness has been here since 10. It is now 4:30, so he's been 6.5 hours, and 3 rounds by any criteria that one would use, each of 5 minutes. When Gina McCarthy was nominated, and I had significant numbers of questions, Barbara Boxer limited me to 5-minute round, 1 5-minute round, and 1 2-minute round. We have more than doubled today that amount of time for questioning.
Mr. Chairman.
Senator.
I'm certainly
No,
not saying that you've been unfair with us, but until this very minute, I don't think it has been clear to anyone that there was a 3-round limit, and I believe you opened the hearing by saying that we'd go on until people's questions were answered. So this is a bit of a novelty, but again, please don't take it as a criticism of your fairness. I think that you have been fair. This is just news, and I do have a bunch of questions right here that I'd hope to ask as what I expected to be a final 4th round.
Well, then I would invite you to please submit those follow-up written questions by tomorrow. Close the business.
Mr. Chairman,
Yes,
Mr.
sir.
Chairman, could I be recognized?
Member and then Senator Booker.
Yeah. I appreciate the way you've conducted this hearing today. Appreciate all the members coming and coming back again and again. When we were talking a week or 2 ago about when to have the hearing, whether to have 1 day of hearings or 2 days of hearings. We were interested, our side was interested in having 2 days of hearings. We were interested in having an outside panel, and it was explained to us that that's not really the tradition of the committee to have an outside panel. And you said I'd prefer to do it in 1 day, and we'll stay as long as people have questions. I think those are almost exactly your words. And that's hard to argue with. You can stay as long as people have questions. Some of our folks have some more questions. I know I do. And we're not running out the clock with honest questions. And I would just ask that just think back on our earlier conversation and just see your way clear to have 1 more round, and we'll call it a day.
Well, I would say a couple of things. One is I offered to start the committee meeting earlier today because there are many of us who have commitments into the evening, people from our home states who are here for the inauguration activities. We have commitments for our home states, and the idea of starting at 9 was rejected. And we wanted to go along, I think, right before the 3rd round. I said, now, if there's going to be ongoing, maybe we should take a break, give the witness an opportunity to take a break. He said, no, let's plow on. The witness has been sitting there now for just about 3 hours. And depending on the wishes of the committee, my preference is to say we have done more than ever done in the last 16 years or 17 years for nominees. I mean, if people have 1 or 2 questions, I would want to give the witness an opportunity to stretch his legs. I'll be happy to stay, and we can come back with a 3-minute round. But I just don't, I think people have obligations and commitments, and we thought we would be completed by now. And it does seem that many of the and for people that are here now, they could go so we have 3 members. If you want to go 2 to 3 minutes or 1 or 2 questions, I think we would be able to accommodate. But to bring back the entire committee and go into the night.
No, I'm not suggesting we bring back the entire committee. They're just suggesting, if we can, maybe we can agree here. Those that are here today, right this moment, if they have questions, give them 5 minutes. And then when they're done, when we're done, we're done.
Yeah. Any objection from our side? These other Senator Inhofe.
Although we would be able to yield back any time that we would have if we didn't want to use it.
Okay. Or you could yield to us.
Okay, I can only say that I've chaired this committee for quite a number of years. I've been through this once before, and there is always an effort by those who are perhaps not really satisfied, as some of the others might be, to try to make it continue on and on and on. I would prefer to go ahead. I think we've all had adequate time, and be prepared to vote.
Well, we don't have a vote scheduled for today on this. We don't have an agreement on that, so there wouldn't be a vote. I would say if
that's the case, then we could confine it to for the record.
Written
questions that they have.
Any other suggestions from the?
Mr. Chairman, I think you've been exceedingly fair, particularly relative to the confirmation of Gina McCarthy, and I think it's purely within your call to have the additional questions be submitted for the record. It's still the opportunity for the witness to answer all the questions. He'll still have to do it before his confirmation, but relative to any other EPA administrator hearing, you've been very generous, very fair, and I think that from that perspective, I think that that's a very fair outcome to still ask the questions, just submit the questions for the record.
Yeah, could I respond to our colleague from Alaska? I don't know if you remember, a year or two ago, there was a joint session of the House and Senate committees, environment committees, and the witness was Gina McCarthy, and I arrived 4 hours into the hearing. And after a while, I was recognized to ask a question. And my first question of Gina McCarthy was, you been here for 4 hours, haven't you? She said, yes. And I said, is there any question you haven't been asked that you wish you had been asked? And she said, yes. I said, what is it? She said, I wish I'd been asked if I needed a bathroom break. Now, I don't know if the witness needs a bathroom break, but if you need one for a couple of minutes, we can arrange that. And I can say, here's what we're asking for. 5 minutes, Cory Booker, Sheldon White House, Tom Carper, we ask a question, and we're done. That's it. Can you handle that? Mr. Pruitt? Why don't you say yes? We're wasting a lot of time here. Otherwise, we'll just keep talking around
As you said, you have a couple of questions. You have a couple. Let's go 3 minutes each, and then we'll call it good. You're up.
Mr. Chairman.
Senator Booker.
I'd asked to be recognized earlier. I do want to.
Oh, I apologize. Yes, sir.
No, I just want to repeat. I do think what Senator Sullivan said. You have been very, very generous. It's true. I appreciate what seems like an accord right now of a few minutes each. I would appreciate that. One thing you didn't mark, which I think should be really important, is I have no sympathy for the nominee and his endurance. I do have for his family behind him who has sat through this, and I just want to mark for the record that they are true champs, and I think that's important to know. And I thank them for their indulgence, not the nominee. But
I would just say
I think that's more evidence that he cares for the children of Oklahoma.
I would just say more people vote for me because of my wife than vote for me, and I would suggest for you as well in the case of this nominee. So
let me yield to Senator Whitehouse.
Okay.
I just wanted to touch on two things, and then we'll wrap up. The first is that on your questionnaire, you listed an email address with a me.com domain as your business email. You also have an oag.ok.gov address. Are there other email addresses that you have, and are there other email addresses that you use for business other than your me.com and your oag.ok.gov email addresses?
I'm sorry, Senator. The email address is not a business email address. And I'm not sure why it was designated as such.
Okay. Well, maybe we can just correct the filing on that.
Yeah.
So
there are no other email addresses, if that's your question, Senator.
We have gone through the cases that you list as your environmental cases. And when we take out the cases that were started by your predecessor, Drew Edmondson, and when you take out the cases that are fish kill cases, which as I understand is a formulaic matter that is resolved by letter at the staff level, you count the fish, you pay the fee. And when you take out the qui tam cases, which are for those who aren't lawyers, a private individual who brings an action, and then the Attorney General can step in and take the action over if they want, but it's brought in the first instance by a private individual. And then if you take out the cases in which you sued EPA, there is virtually nothing left. And in addition to that, we have that you closed the Environmental Protection Unit in Oklahoma as a freestanding unit. You told me when we met that you had rolled it into your federalism unit, but I was just on the federalism unit's website, and the word environmental doesn't even appear on that. And it appears to be run by the Solicitor General, and it says over and over again that it's involved in appellate litigation. And of course, if you're bringing an action, you're not starting at the appellate level. Finally,
Senator, if I may, the Deputy Solicitor General, Clayton Eubanks, was actually employed by the previous Attorney General. He has been designated the Deputy Solicitor General and is responsible for environmental-related advice and consent to those agencies.
Yeah, that's a
Actually,
different
7
function, though. That's a different function than to bring an action. I've been an Attorney General, too. I know the difference. The Attorney General has an obligation to provide lawyers to give advice to agencies, but you also have the authority to bring criminal actions, if you wish, and you have the authority to bring civil actions, if you wish. And it's those authorities that I believe have not gotten much attention. And the last piece of that, because you will have a chance to respond, but I'm on a short clock, thanks, is that there was an Oklahoma Environmental Crimes Task Force that your predecessor led, and it describes, and I'd ask to have these documents put into the record, from 1997 to 2010, the OECTF, the Environmental Crimes Task Force, or the Environmental Protection Unit, in conjunction with EPA and other entities, conducted 142 criminal investigations, resulting in 56 prosecutions. Criminal cases resulted in individual convictions on 110 felony and 21 misdemeanor counts, corporate convictions on 10 felony and 3 misdemeanor counts, $8 million in fines, 28 years of jail time. We can put it in the record. Is there even Do you even participate in the Oklahoma Environmental Crimes Task Force still?
Without objection.
Senator, as I've indicated, we work each day with our Department of Environmental Quality on enforcement along with other agencies. I guess it's a matter of, quote unquote, who takes the credit for that type of enforcement. But those individuals have offered statements to this body. They are a matter of the record. You've heard statements that the chairman has referred to that we have worked diligently with those agencies to enforce appropriately. And I would refer to their statements in response.
Thank you, Senator Booker.
Thank you very much. So first of all, I appreciate you talking about environmental justice and mentioning that. We did talk about that, and I felt good about your personal commitments to at least me that you would pursue that. I just want to go through this last point, and I'm going to put together a fact pattern here, then let you have at it and dispute it. I know there's at least one point in here you dispute, but I really want to get to what I draw from the facts, and you can, again, have the last word. So what I'm seeing when I put together all the facts, just a pattern. You know, there was a litigation from your predecessor that you declined to conclude when you got in against polluting poultry producers who were dumping hundreds of thousands of tons of chicken waste into the Illinois River shed. You shut down the environmental enforcement unit in your office. This is the one I know you do not agree with me on, but I see it as that you also attempted to suspend Oklahoma's water quality standard for 3 years. But the last fact, and again, you have the last word here, sir, is that you also supported a constitutional amendment, State Question 777, the so-called Right to Farm Amendment, that would have made it more difficult for the Oklahoma State Legislature. Again, you talk about federalism. Now it's trying to take the teeth out of the Oklahoma State Legislature and local governments to enact their own environmental laws in the future. And this kind of support, and I looked all throughout magazines, you're going in support of this. It's clear. Here you are in the pro and con about supporting 777. Here is, most of the editorial boards were against you on this in your state. Here's one from Tulsa World Endorsement that said the measure would prevent future state and local regulation on farming and livestock activities unless the state has a compelling state interest. A very high legal standard, as I know, not the lawyer that you are, sir, but I know that that is a very hard one standard to meet. And so this is the challenge, is that this idea that you're supporting federalism versus, it seems to me, a pattern of you being on the side of the polluters and even trying to take the teeth out of the state legislature's ability to regulate these harmful environmental toxins. I'm happy that this ballot initiative was overwhelmingly defeated by Oklahoma voters, but as I see you ascending potentially to this very important position, sir, I just worry about whose side you're going to be on, given the fact pattern that I have about big industry, about big pollution, especially as I know the billions of animals that we have in CAFOs that are poisoning rivers all over this country. I really just want you to respond to that, sir. And I'll say, because this will be my last word, you will have it. I want to thank you for your indulgence. I know this has been a long day, and I want to thank your family as well.
Thank you, Senator. And let me respond. There's been some confusion about the litigation. You made reference to several things there, and if I may respond to a couple. The litigation to which you refer, Senator Bozeman actually referred to it as well. My predecessor did bring an action, approximately 2007 timeframe, against the poultry industry and many other defendants in the Northern District of Oklahoma. That case had been fully litigated. Submitted to the court for decision before I ever came into office. It was an example of potentially regulation through litigation, and I've talked about that earlier in response to questions. I had every authority to dismiss that case when I came into office. I did not. That case is still pending today, awaiting a federal judge's decision. I've taken no action to undermine that case. I've done nothing but file briefs in support of the court making a decision. That's a point of clarity on the litigation. With respect to our office, I submitted this in response to Senator Whitehouse's request. We met last week, and he asked about FTEs and budget. I've submitted responses to him. We have almost a $700,000 budget that the administrator of our office has attributed to environmental related activities, and 7 FTEs that are associated with that as well. So I want to make sure that those two items were shared with you in response to your comments.
You have nothing to respond to on the state question 777?
The state question 777, we're actually involved in the ballot drafting of those things. And so though you represented that I was actively involved in an endorsement or involved in I really was not as far as the actual vote. And now there was some op-ed and some decisions, but I've tried to make sure that I didn't get involved in that because of our other obligations in the office.
Senator Carper.
And I can submit this for the record, sir?
Yeah, without objection.
Thank you, sir.
Mr. Pruitt, earlier today, I mentioned that I had submitted a list of about 50 questions to you shortly after Christmas, asked for a response by January the 9th, and got none. And I asked my staff earlier this morning if we'd gotten written responses on those questions as of today, and I understand that we have not. You're going to receive a number of questions for the record from us, Democrats and Republicans, and I'm anxious to see what your responses are to those questions. But we need your answers, and we need good answers. And the idea of waiting 2-3 weeks and not providing anything is just unacceptable. So just to put that out there.
Well,
Second, I would like to ask you a question,
if I may offer this. I tried to, and I talked to the chairman about this, with respect to your questions you submitted. I was respecting the protocol of the chair in responding to those questions and committed that those questions would be answered for the record post the hearing, and that's what I was directed to do by the chairman.
All right. Second, based on your earlier statements, I just want to clarify something. If confirmed, can we have your assurances that the EPA will continue to regulate mercury emissions from power plants under Section 112 of the Clean Air Act, and you will not defer to the states?
Mercury under the Section 112 is something that EPA should deal with and regulate.
Thank you. I came across a quote from you that said, I think you stated the following about an EPA rule involving cross-state smog pollution. And the EPA rule, I think you were quoted as saying, threaten the competitive edge Oklahoma has enjoyed for years with low-cost and reliable electric generation. This low-cost energy not only benefits Oklahoma manufacturers, but gives our state a considerable edge in recruiting new jobs. And the question I would ask, at the peril of those of us who live in states that are downwind from where Oklahoma might be, as you lower your energy costs to benefit Oklahomans, I just want to ask you, in the spirit of the Golden Rule, keep in mind what that means for us. Keep in mind what that means for us. Because in my state, I said earlier on, I could shut down my state's economy, and we still would have been out of compliance with any number of clean air requirements. And that was not because of anything we put up in the air, but because of what folks out to the west put up in the air, and it eventually came down to the end of America's tailpipe. I would just ask that you do that. And last, we have a chart, just quickly chart. You see this chart? This is an interesting chart. This is what we call a busy chart. It's a busy chart, and it looks at the issue of cross-border air pollution. As you can see with this chart, smog pollution in our country moves all over the place. I mean, all over the place. As I mentioned, as Delaware's governor, I'm going to shut down my state in order to come into compliance with clean air challenges. Under your vision for EPA, it sounds like states will be left on their own to deal with this very complex problem that we see demonstrated right here. And I would just ask, how do states address this pollution, this kind of pollution you see demonstrated here, without the assistance of the EPA?
Well, Senator, as I indicated earlier today, I believe that, as an example, the cross-state air pollution rule to which you just referred is a very important authority that the EPA needs to exercise. It needs to do so within the processes that have been provided by the statute, but it's something that's very important for the EPA to perform and execute.
All right. Mr. I have a unanimous consent request to submit for the records, Mr. Chairman. to a number of letters, concerns that about, and in many letters sought opposition to, some cases for, other cases opposition to Mr. Pruitt's nomination. There's about 14 in all. I would just ask him to consent to put
Without
those in
objection.
direction. Thank you so much.
Thank you.
And again, to Mr. Pruitt, to your family, thank you all for joining us today. I just want to say I could pick Cade, your son, sitting right behind you. I could barely see Cade's lips moving when you spoke, and so I suspect he has a future in law. I'm not sure, but
We'll see.
And,
Thank you, Senator.
And Attorney General Pruitt, I do want to follow you. As you said, you were instructed by the committee. I have a copy for the record of the January 9th letter, which was the day that you were asked to submit the 52 answers to the responses. It's a letter from me to the ranking member saying, please note the EPW committee does not require nominees to respond to questions in advance of a hearing. And I know you'll be responding to the written questions that will be submitted by tomorrow night.
But, Mr. Chairman, could I just add a short thing? But that's a conversation between you and the chairman. I understand that. But again, I just reiterate, you'll receive a lot of questions, including some that have been unanswered from the 50 or so I submitted 2 or 3 weeks ago. We need your responses. We need your responses. And I hope the chairman will give you a reasonable amount of time to respond to those questions, because there'll be quite a few of them. And they're not going to be like multiple choice answers. They won't be true and false. They'll be more complex. Thank you.
Additionally, I'm going to introduce, for the record, an article from The Economist about Mercury and the Mercury rule. And it's interesting because it says the rulemaking is being made to look more beneficial under Barack Obama, but it goes to say a casual listener would have assumed that all these benefits came from reduced mercury. In fact, reduced mercury explained none of the purported future reduction in deaths, heart attacks, and asthma, and less than 0.01% of the monetary benefits. Instead, almost all of the benefits came from concomitant reductions in a pollutant that was not the principal target of the mercury rule, namely fine particles. And I'll submit that for the record as we look at the issues going into in the future. So I want to thank all of the members of the committee for your patience. I certainly want to thank the nominee for his time and his testimony today. The hearing is adjourned.
Thank you, Mr. Chairman.
Good.
Anyone's interested, I'm a Pennsylvania mom, and I have a child with asthma. I've spent more than 6.5 hours every time I go to the ER. Disappointed. At least my moms like myself, every single day, spend more than 6.5 hours with their children who can't breathe.
That was interesting.
hours. Every time I've been in the ER, my daughter can't breathe because of asthma. It's been longer than 6.5 hours. We're tired of having our kids sick.
If you missed any of today's hearing, for Scott Pruitt to serve as the next EPA administrator, just go to our website, cspan.org. We'll have it available there. You can just type Scott Pruitt in the search line. Scott Pruitt, just one of the Trump administration nominees on Capitol Hill for confirmation hearings today. Commerce Secretary nominee Wilbur Ross and UN Ambassador nominee Nikki Haley also had confirmation hearings.